Consideration of the report of the Standing Committee on Justice, Legal Affairs and Human Rights on a petition to the Senate by Ms. Christine Njoki Mweru regarding incomplete investigations and failure to arrest and prosecute suspects involved in the abduction and disappearance of Mr. Joshua Gishuki Mwangi.
Chairperson Jailak.
Mr. Speaker, I beg to move the motion that the Senate adopts the report of the Standing Committee on Justice, Legal Affairs and Human Rights on a petition to the Senate by Ms. Christine Njoki Mweru regarding incomplete investigations and failure to arrest and prosecute suspects involved in the abduction and disappearance of Mr. Joshua Gishuki Mwangi, laid on the table of the Senate on Thursday, the 5th of June, 2025. Mr. Speaker, I request the Honorable Senator Veronica Maina to second this motion. I beg to move.
My Honorable Speaker, thank you for the opportunity. I do hereby second the report that has been presented to the House by the Chair Jailak Committee. Thank you.
Senator Fernandi, take your seat. I will propose the question. The Senate adopt the report of the Standing Committee on Justice, Legal Affairs and Human Rights on a petition to the Senate by Ms. Christine Njoki Mweru regarding incomplete investigation and failure to arrest and prosecute suspects involved in the abduction and disappearance of Mr. Joshua Gishuki Mwangi, laid on the table of the Senate on Thursday, 5th of June, 2025. Now, following the resolutions made earlier, I will proceed to put the question. That the Senate adopt the report of the Standing Committee on Justice, Legal Affairs and Human Rights on a petition to the Senate by Ms. Christine Njoki Mweru regarding incomplete investigations and failure to arrest and prosecute suspects involved in the abduction and disappearance of Mr. Joshua Gishuki Mwangi, laid on the table of the Senate on Thursday, 5th of June, 2025. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. Next order.
Order number 12, motion. Report of the Standing Committee on Labor and Social Welfare on a petition to the Senate by Mr. Lawrence Ndutu on behalf of 125 other former employees of Kenya Breweries Limited concerning failure by the Kenya Breweries Limited, Kaplan and Stratton Advocates, and Harrison Kianjui Advocates to pay compensation awarded to the petitioners.
The Chairperson, Labor and Social Welfare Committee.
So, Nizikate short. Thank you, Mr. Speaker, for giving me the opportunity to give this report. Mr. Speaker, so I beg to move the motion that the Senate adopts the report on Standing Committee on Labor and Social Welfare on a petition to the Senate by Mr. Lawrence Ndutu and on behalf of 125 other former employees of Kenya Breweries Limited concerning the failure by the Kenya Breweries Limited, Kaplan and Stratton Advocates, and Harrison Kinyanjui Advocates to pay compensation awarded to the petitioners laid on the table of the Senate on Wednesday, 9th July 2025. Mr. Speaker, sir, the petition concerning the failure by the Kenya Breweries Limited, Kaplan and Stratton Advocates, and Harrison Kinyanjui Advocates to pay court-awarded compensation was presented to the Senate on Tuesday, 18th February 2025, in accordance with the Senate Standing Order 236 and referred to the Standing Committee on Labor and Social Welfare under Standing Order 238 1, the petition was submitted by Mr. Lawrence Ndutu and on behalf of 125 former employees of Kenya Breweries Limited were allegedly wrongly dismissed in breach of a memorandum of agreement. It was reported that the petitioners had filed a case, Lawrence Ndutu and 125 others versus Kenya Breweries Limited, and another HCC number 279 of 2003, and were represented by Harrison Kinyanjui advocates. The court delivered judgment in their favor, awarding them a sum of total of 9,180,675, and ordered that each individual be compensated with 1 month's salary for loss of employment. In their prayers, the petitioners requested the Senate to, 1, investigate the matter and recommend the settlement of outstanding compensation, and 2, make recommendations regarding the conduct, both acts of commission and omission of advocates involved, namely J. Harrison Kinyanjui advocates and Kaplan and Stratton advocates. Mr. Speaker, sir, the committee interacted with the petitioners and other shareholders who include the Advocates Complaints Commission, ACC, Kaplan and Stratton advocates, and Harrison Kinyanjui advocates, providing an opportunity for the parties to present evidence and respond to allegations. The committee observed that the matter has remained unresolved for over 2 decades. During this period, the petitioners consistently raised serious concerns about the conduct of their former advocate, including allegations of dishonesty and failure to account for clients' funds. These allegations stem from a dispute over the illegal fees charged and how the case was ultimately settled. The committee noted that Kaplan and Stratton advocates, acting on behalf of Kenya Breweries Limited, that the matter had been conducted as evident by signing a discharge voucher and consent agreement, but that the amounts paid did not include the 1 month's salary per individual. Mr. Speaker, sir, the committee made the following recommendations in response to the petitioners' prayer. The petitioners actively follow up on the certificate of urgency application filed by Harrison and Kinyanjui co-advocates 17th May 2025 regarding enforcement of the outstanding 1 month salary awarded to ensure resolution of their claim. To Harrison Kinyanjui and co-advocates, submit monthly written updates to the committee on the status of and progress of the pending court application until its final determination. 3, despite the actions of the advocates and the parties of signing the discharge of vouchers and settling the matter finally being legally justifiable, it remains morally and objectionable, the committee recommended Kaplan and Stratton to pay 1 month salary awarded by court to the petitioners. Mr. Speaker, sir, I beg to move and ask Senator Seki to second.
Thank you very much, Honorable Speaker. I hereby then second this report and support that the committee interrogated the stakeholders, particularly the advocates, Kaplan and Stratton, and even Harrison Kinyanjui. Honorable Speaker, we found that these employees from Kenya Breweries Limited had a right to be paid their 1 month salary. And again, for them to have the money that has been given by the court of 9 million. Honorable Speaker, the committee recommended that this money be paid within a very short time, with no other waste of time. Otherwise, thank you very much. I want to second this report. Thank you.
Senator Fernandez, take your seat. I will now propose the question that the Senate adopt the report of the Standing Committee on Labor and Social Welfare on a petition to the Senate by Mr. Lawrence Ndutu on behalf of 125 other former employees of Kenya Breweries Limited concerning failure by the Kenya Breweries Limited, Kaplan and Stratton advocates and Harrison Kinyanjui advocates to pay the compensation awarded to the petitioners laid on the table of the Senate on Wednesday, 9th July 2025. Again, pursuant to the resolution that has been made earlier on, I will proceed to put the question. The Senate adopt the report of the Standing Committee on Labor and Social Welfare on a petition to the Senate by Mr. Lawrence Ndutu on behalf of 125 other former employees of the Kenya Breweries Limited concerning failure by the Kenya Breweries Limited, Kaplan and Stratton advocates and Harrison Kinyanjui advocates to pay compensation awarded to the petitioners laid on the table of the Senate on Wednesday, 9th of July 2025. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. Before I call the next order, allow me to make this communication. Honorable Senators, I would like to acknowledge the presence in the public gallery this afternoon of visiting teachers and students from Tabaka Girls Primary and Junior School in Kisii County. The delegation comprises 33 teachers and 168 students who are in the Senate for a one-day academic exposition. Honorable Senators, in our usual tradition of receiving and welcoming guests to Parliament, I extend a warm welcome to them, and on behalf of the Senate, on my own behalf, wish them a fruitful visit. I will call upon the Senator for Kisii County under 1 minute to extend a word of welcome, and also Senator Esi Okenyuri, also under 1 minute to extend the word of welcome. Proceed.
Mr. Speaker, thank you for giving me the opportunity to recognize the presence of Tabaka Girls Boarding School. Mr. Speaker, Tabaka Girls Boarding School is a Catholic school which comes from the constituency of South Mugirango. Historically, Tabaka has been a school of excellence in Kisii. They also do have a very big hospital in the same Tabaka place, and it's basically within the family of the Catholic Church. And girls, I wish you well. I'm happy that you're here. Mr. Speaker, where I'm standing, I'm not able to lift my head so that they can see me, but I'm sure they can hear my voice. I welcome you to this Senate. It's a place where you come and learn everything. and I'm happy that you've come here today. Now, Mr. Speaker, once mukishamaliza, I'll buy you a cup of tea. Thank you very much, Mr. Speaker. And I will welcome another leader in our delegation from Kisii County, a lady called Essie Okenyuri. You know her? Very, very, very highly talented and gifted lady. Essie, could you please say a few? Thank you.
Thank you, my senior Senator Onyonka. Mr. Speaker, I also wish to take this opportunity to welcome the girls to Senate under the stewardship of Sister Lillian. I also saw one of my colleagues in campus, that's Mr. Arthur Bells, a teacher in that school. Mr. Speaker, Tabaka, where this school is situated, actually has one of Kenya's strategic minerals, soapstone. So apart from that, they're also bringing up girls who are engaging in quality education. And because of whatever the girls are doing, even before they came in, he had an opportunity to engage them out there through Essie Okenyuri Nyaituga Foundation, and I gifted them. I wish you the very best, girls, as you go back. You can dream and go beyond what we are now. Thank you very much.
Next order.
Order number 13, motion. Report of the Standing Committee on Justice, Legal Affairs and Human Rights on its consideration of the sessional paper number 3 of 2023 on the Kenya policy on public participation.
Chair Jailak.
Mr. Speaker, I beg to move that the Senate adopts the report of the Standing Committee on Justice, Legal Affairs and Human Rights on its consideration of the sessional paper number 3 of 2023 on the Kenya policy on public participation laid on the table of the Senate on Wednesday, 14th of May, 2025, and approved sessional paper number 3 of 2023 on the Kenya policy on public participation. Mr. Speaker, briefly, this is a policy that was published in the year 2023 and tabled in the House on 25th of April 2024. It was thereafter committed to the Committee on Justice and Legal Affairs for its consideration, which, upon various engagements with stakeholders, efforts have been made by the government, that is through the executive, and also to formulate suitable frameworks for purposes of ensuring that public participation is done. Mr. Speaker, in the course of this particular engagement by the committee, there are several areas which were identified as very specific and particular policy areas, which included areas of particular concern that highlighted the concerns which have been raised by members of the public, as well as pronouncements that have come from various courts, including the case that we got from Kiambu County that has sort of directed most of the public participation engagements. That particular matter is one of the cases that the committee engaged with in coming up with these various areas which we picked for purposes of consideration and which fed into our resolution, Mr. Speaker, gaps which were identified by the matters which have been litigated in various court sessions, the challenges which were also requiring various improvements, and largely, Mr. Speaker, to ensure that we entrench directions and options available to make sure that there is meaningful public participation by the public in areas of interest. Mr. Speaker, this particular policy was also brought about by various bills that has previously been tabled before this House. I recall in the course of our participation in dealing with the petition, with the policy, Mr. Speaker, were around 3 bills which have been tabled before this House. One of the bills was tabled, I believe, by the Attorney General Emeritus. And unfortunately, those bills have never garnered the requisite numbers for purposes of passage in the 2 houses. But with this particular report, Mr. Speaker, we have engaged both executive as well as other major stakeholders, and we believe that this meaningful engagement will give a guide on how to draft a relevant involving bill by the Office of the Attorney General for purposes of tabling it in the House to ensure that it meets the standards that the courts have pronounced themselves in the matters litigated before it. And Mr. Speaker, the report by the committee will definitely inform the bill that will be drafted, because the recommendation that the committee has made is to direct the Office of the Attorney General to come up with a draft bill for purposes of engaging the public as well as the legislature on ultimately enacting that bill. Mr. Speaker, as I move, I want to request Senator Veronica Maina to second this bill and urge members to support the moment that draft bill gets to the floor of the House for engagement and ultimate passage. I urge all the members to support. Mr. Speaker, I thank you.
Thank you, Honorable Speaker, for this opportunity, and I beg to second the report that has been moved in on the floor of this House. Mr. Speaker, the report that has been brought to the House is an approval by JLAC that the Kenya policy on public participation should be allowed to proceed through the lawmaking process to make a legal framework for public participation. The policy reaffirms the government's commitment to exercise effective public participation strengthened by national legal framework. Mr. Speaker, it bestows upon the state and mandates the state to give the public access to information and also to provide a civic education framework for coordination and for enabling all actors to give quality civic education, and to also give capacity building and undertake coordinated and integrated capacity building towards empowering responsible citizens and public institutions. It also promotes effective public participation in planning, budgeting, and implementation of approved plans and budgets, and inclusion of marginalized groups, including children, women, minorities, at all levels of governance. Honorable Speaker, this policy is going to finally show us what is the right way of conducting public participation. If you notice, Mr. Speaker, a lot of laws that have been enacted in this parliament have been negated, or they have been rendered null because of poor public participation. Now, with this framework, Honorable Speaker, it will settle a few issues that have moved against the enactment of bills, or that have caused bills to be rendered nugatory. And it is going to now make it clear, Honorable Speaker, that when quality public participation is conducted before any bill is passed, then it will pass the test of being acceptable even to the citizens upon which such law will be applied. And only yesterday, Honorable Speaker, I was put to task by a certain group of people who live in Lavington, and they needed us to explain how they participated in a public participation, and yet there were certain things that happened that they did not anticipate, because they said all the residents that sat in a certain public participation had rejected the zoning of petrol stations within the residential areas in Lavington, Honorable Speaker. I believe after the passing of this framework and this policy being approved, it is going to settle the parameters within which the contribution from the public on issues that affect them are going to be determined, so that if residents reject a certain project or reject something that has been done within their vicinity, Honorable Speaker, we will now have proper parameters that will govern whether that rejection, what is the threshold that rejection should be accepted, so that the project cannot be applied when citizens have said they do not want to have that project in their area, or if their area is being rezoned. For instance, if factories are being set within a residential area, the residents can actually indicate to the public entity that is conducting that public participation, Honorable Speaker, that they are not interested in that project, Honorable Speaker. It is also going to indicate, hopefully, who should participate in that public participation. For instance, Honorable Speaker, is it right for a public officer or a political leader to call in workers who are working within their offices, or family, or friends, or relative, fill a room and purport to have conducted public participation on a specific aspect? all these issues will now be settled, and it will be easier to determine whether what has been conducted as public participation can be acceptable and would pass the constitutional test or threshold of being able to determine the issues that are being determined or by the public or by the public entity. It puts the duty on both the public entity and also the citizens. No longer will citizens purport also not to be aware that certain projects are being carried out or decisions are being made which will affect their social, economic, political rights. And maybe, Honorable Speaker, if this policy had been passed before the 25th of June, maybe we would not have riots or demonstrations on the streets, because citizens will have participated in decisions that are informing legislation and that are informing policy within the public sector. So, Honorable Speaker, with those many remarks, I affirm and support the report that has been brought to this House, and I beg to second this report. Thank you.
Honorable Senators, will now proceed to propose the question that the Senate adopt the report of the Standing Committee on Justice and Legal Affairs and Human Rights on its consideration of the sessional paper number 3 of 2023 on the Kenya policy on public participation laid on the table of the Senate on Wednesday, 14th of May, 2025, and approve sessional paper number 3 of 2023 on the Kenya policy on public participation. Again, bound by our earlier resolution, I'll proceed to put the question. That the Senate adopts the report of the Standing Committee on Justice and Legal Affairs and Human Rights on its consideration of the sessional paper number 3 of 2023 on the Kenya policy on public participation laid on the table of the Senate on Wednesday, 14th May 2025, and approve sessional paper number 3 of 2023 on the Kenya policy on public participation. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. Next order.
Order number 14, motion. Report of the Standing Committee on Devolution and Intergovernmental Relations on its inquiry into the state of governance in the county government of Garissa, arising from a statement sought by Senator Haji Abdul Mohamed MP.
Senator Maruma, what is your intervention?
Sorry, I've been informed that you had passed some resolution, but no, public participation is an extremely important agenda in this House and for Kenya. I thought maybe you could comment one or two, because when I had the Chair Jailer commenting, he said that we have to throw this agenda of coming up with a law on public participation to the Attorney General. Why can't we do it, Mr. Speaker? Because this is a house of making laws. And having now a policy, this would be the best time to do a law on public participation, Mr. Speaker. I'm wondering what the challenge is.
Yes,
because then Jailer can pick up that issue.
Honorable Senator, a resolution has been passed by this House that immediately a report by over motion is moved and seconded, we straight away go to putting of the question. So we are bound by the resolution of the House. The Chairperson, Standing Committee on Devolution and Intergovernmental Relations.
Thank you, Honorable Speaker. Honorable Speaker, I beg the Senate to adopt the report of the Standing Committee on Devolution and Intergovernmental Relations on its inquiry into the state of governance in the county government of Garissa, arising from the statement sought by Senator Abdul Haj, laid on the table by the Senate on Wednesday, 28 May 2025. Honorable Speaker, Senator Haji actually sought to know, to have the list of individuals or liaison committees, or liaison of the committee, executive committee, members, chief officers who are not been appointed since 2022, and the county government of Garissa was operating with only one chief officer out of the 30 now they have appointed. So Haji wanted to know and have the list and why the chief officers are not appointed since 2022 up to July 2024, when the committee intervened. Honorable Speaker, the county was using or appointed directors who have been executing the duties of chief officers, which was actually illegal, and the same officers who have been acting as chief officers were not approved by the counties, by the assemblies. Honorable Speaker, on 16th May, the governor of Garissa appeared, interrogated by the county. Also, there was an issue of where about 200 members of the staff of the previous government that were laid out, laid out of job, and those members who have been laid out of went to court. And as such, there was a Garissa petition number E205 of 2022 that have asked the Public Service Commission to at least undertake and appear and appraise the committee and the court on how this matter has been, the due process has not been followed. Honorable Speaker, also the committee has invited the Garissa Public Service Board, who appeared in front of the committee upon deliberation and due inconclusive submissions made by the board. The committee directed the board to provide a comprehensive report on all matters related to human resource management in Garissa County within 3 months. However, up to now, it has not been submitted, and a reminder has been written to the committee, to the board. Honorable Speaker, we also invited the principal of the devolution committee, the State Department of Devolution, and they are yet to appear. And I think also a reminder has been sent to the PS. Honorable Speaker, the committee did in-depth analysis and found that the Garissa County had infringed Section 45(1) of the County Government Act 2012 that provides that whenever vacancies arise to the office of the county chief officers, the respective governor shall, within 14 days, nominate qualified and experienced county chief officers. However, the governor disregarded this advice and contravened the act of Section 45(1). The exercise of recruitment of the county chief officers began only after the committee commenced inquiry into the matter. The board received request on 20th January 2024. On 2nd January 2024, from the county secretary to commence recruitment. The board approved the request, and subsequently the chief officers assumed office in July 2024 after recruitment. However, we found that the county actually recruited 30 chief officers against 10 CSM. And I think that is actually the higher side. And there was a kind of employment. And then this has really costed the county to have a lot of staff. And today they're spending almost 56% of their money on staff emolument. Honorable Speaker, the county government since appointment has undertaken, there's a huge number of chief officers and sustainable burden for the county wage bill. And the committee felt that we need to review that kind of appointments in future. Based on the findings, Honorable Speaker, the observation of the committee made the various recommendations that the Garissa County Service Board should review the schemes of service and organization structures within the county public service. The Auditor General should conduct a special audit within 6 months upon the resolution of this report of all financial transactions made by the Garissa County Executive from the assumption of office of August 2022 to July 2024, being the period which the county had no county chief officers in place to address any irregularities or unauthorized expenditures incurred by the county executive. 3, the county government of Garissa should expedite the transition to fully digitized payroll systems of fully integrated county employees into integrated payrolls. 4, in line with the constitutional role of the capacity building and technical assistance to the counties, the national government undertake Schedule 4. The State Department for Public Service and Human Capital should provide capacity building trainings and sustain of programs to Garissa County. 5, the Garissa County Public Service Board should submit to the Senate the report of the Human Resource Audit Exercise requested by the committee within 14 days upon the adoption of this report. Additionally, the board should submit a list of all the current employees that the qualifications and terms of employment interview done and reports of the county public service. 6, the Auditor General should undertake a comprehensive audit of Garissa County human resource management and staff establishment within 6 months upon the adoption of this report. The audit should include, but not limited to, the roles of the County Public Service Board and whether all requirements of employees are carried out, the existing human resource policy, the approval of staff establishment, the management of the county wage bill, and especially personnel embezzlement, the rationale behind appointing 30 chief officers against 10 county executive members. 7, Garissa County government should, within 3 months upon the adoption of this report, submit to the Senate a report on the current status of the wage bill and any other measures taken since 2024 to ensure compliance within limits of 35%. 8, Schedule 4 of the Constitution under paragraph 32 allocates the role of capacity building and technical assistance to the counties of the national government, and in this regard, the provision the Senate should, within 3 months upon the adoption of this report, build the capacity of the county assemblies, because there's a lot of undercapacity in that place. 9, amendment of the County Government Act 2012 to clearly establish timelines for the nomination and appointment of county executive committees, members, and county chief officers whenever a vacancy arises. 10, amendment of the County Government Act 2012 to clearly provide the maximum and minimum number of county chief officers to be appointed in any county government. The committee proposes the number of chief officers in a county government should be a minimum of 14 and a maximum of 20. 11, amendment of the Control of Budget Act 2016 by enhancing the role of the Controller of Budget to include reviewing of the requisitions by the county departments into the county treasuries before approved of withdrawal of funds. 12, the amendment of the County Government Act 2012 to clearly segregate the roles of the County Public Service Board, the County Secretary, and the County Executive Committee member in charge of matters relating to county public service. 13, amendment of the County Government Act 2012 to provide the clarity, situations, and limits upon which the CCM Finance can designate accounting officers to be responsible for managing the finances of the county government entities, in addition to further provide for clarity on the limitations and powers and functions of officers designated as a county officers in acting capacity, as well as the durations in which a person may serve in such role. Honorable Speaker, with those many remarks, I wish to move the motion and request the House to adopt the report of the Standing Committee on Devolution and Intergovernmental Relations on its consideration of the state of governance in Garissa County, and request Senator Sharagay to second. Thank you.
Thank you, Mr. Speaker. Sir, as I rise to second, I want to thank the committee chairperson, Senator Habas, and his distinguished members of the Devolution Committee by saying the following. Mr. Speaker, the intention and aim and the intent of devolution was to allow efficiency, development, and commitment in terms of utilization of resources. So, Speaker, secondly, is to ensure that the law is followed. Mr. Speaker. What happened in Garissa is very unfortunate, Mr. Speaker, because the fact that when governor and the county government came into force in August 2022, when all of us were being sworn in, the County Public Service Board of Garissa advised then the governor to start the competitive recruitment of chief officers, Mr. Speaker, but that was disregarded by the governor against the advice, therefore violating Section 45(1) of the County Governments Act. Mr. Speaker, the reading of that violation and ignoring and violating the law forms a basis of impeachment under Article 181 on removal of a governor. Mr. Speaker, what was committed is an impeachable offense against the governor, because by staying from 2023 September up to July 2024 without chief officers raises very critical factors, Mr. Speaker. Because one, you have to note, Mr. Speaker, that the fact that there was no chief officers who made requisitions, yet we know chief officers, Mr. Speaker, as per the structure of the county government, and you have been lucky enough to serve the great people of Kilifi for 10 years, Mr. Speaker, is these are accounting officers in any department, Mr. Speaker. So what happened in Garissa County government, Mr. Speaker, the violation of the law, they serve no excuse, Mr. Speaker. And we expect necessary agencies, including EACC and others, should have commenced investigations. Even the Garissa County Assembly should have cited governor for a violation of the Constitution and the law and forms an impeachable offense under Article 181 of the Constitution, Mr. Speaker. Mr. Speaker, secondly, and you know this country, Mr. Speaker, we must be careful. You know, this is bad manners, as my brother Senator Onyonga would call it. Where, Mr. Speaker, you're having 10 CCs, 10 against 30 chief officers, Mr. Speaker. One, it is not sustainable. Two, it is violation, and it will ensure the wage bill, which has been put at a threshold of 35%, is being violated, Mr. Speaker. Why would you have 10 CCMs and 30 CEOs? It is not sustainable, Mr. Speaker. It is not even reasonable. It is not morally right. It is legally wrong, Mr. Speaker. It violates the Constitution, both the spirit and substance, Mr. Speaker. So it doesn't make sense that the Garissa County Governor, Nathif Jama, and his government can hire 30 chief officers against 10. This is, Mr. Speaker, even if you wanted to fulfill the clan politics that we know exists there, it is not the right thing, Mr. Speaker. I know it's playing for political expedience and political gallery, Mr. Speaker. 10 CCMs against 30 chief officers doesn't make sense, Mr. Speaker. And that is my point number 2. Point number 3, Mr. Speaker, I agree, because I'll just skim through, Mr. Speaker, with indulgence by giving my colleagues the conspectus of the committee report, Mr. Speaker. Mr. Speaker, the OAG, the Auditor General, in fact, I want to request the committee, I don't know whether we'll amend, that apart from the Auditor General, we must include the EACC to investigate and do a special audit with a possibility, Mr. Speaker, of investigation and prosecution of senior county officials of Garissa County Government within 6 months. Because, Mr. Speaker, from August 2022 to July 2024, Mr. Speaker, there was no chief officers in office. And therefore, it meant, Mr. Speaker, who was doing requisitions? The controller of budgets, Mr. Speaker. Who was making financial requisition for the spending of Garissa County Government, Mr. Speaker. And therefore, there was a possibility of mischief and mystery, Mr. Speaker, in terms of utilization of the resources within the month of August 2022 to July 2024, Mr. Speaker, where there were no chief officers. Who was doing the spending, Mr. Speaker? Who was the accounting officers? Does it mean the governor was the one doing requisition and accounting at the same time, which was a clear violation of Public Finance Management Act, Mr. Speaker, violation of the Constitution 2010, violation of county governments, Mr. Speaker, and therefore I agree that within the 6 months, the Office of the Auditor General must do a special audit, Mr. Speaker. Number 4, Mr. Speaker, is in IPPD, Integrated Payroll and Personnel Data System, IPPD. We must be told, Mr. Speaker, there are so many casual workers, Mr. Speaker, and I have a benefit of being a member of public accounts. This Garissa County, Mr. Speaker, has a very unfortunate and misnomer, Mr. Speaker, of having many casual laborers, therefore driving the wage bill beyond 35% as provided by the law, Mr. Speaker. So on this IPPD, Mr. Speaker, it is very unfortunate that, Mr. Speaker, that we must be told that why are many workers in Garissa County are being paid outside integrated payroll and personnel data system, which is IPPD, Mr. Speaker. Mr. Speaker, on the issue of technical assistance, I think that the chair has captured it very well. Mr. Speaker, the human resource audit, I agree that the County Public Service Board of Garissa must provide the human resource audit within the next 14 days, Mr. Speaker. I hope as we adopt the report in the next 14 days, I know we are going for devolution conference, but I hope the devolution committee led by ABO Chair Senator Abbas should get this report on human resource audit. Mr. Speaker, we are tired in counties where we have so much excess casual workers, Mr. Speaker. Like, for example, in Nandi, the investigations into ghost workers within the payroll scandal by ESCC is yet to be concluded, Mr. Speaker. You know, you find in county government, Mr. Speaker, in conclusion, is you find one person can do office cleaning, serve tea, do cleaning and serve tea, and maybe pick newsletters or pick envelopes, Mr. Speaker. But you find in counties, one person has been hired to give tea, one to provide letters, Mr. Speaker, one to do cleaning. That job can be done with one person. And that is what is killing these counties, Mr. Speaker. That is what is killing these counties. I remember, Mr. Speaker, even in Kisii, the wage bill is approaching 70%. That means Kisii County cannot be sustainable, Mr. And as a public accounts, Senator Onyonga is aware that we called to order the governor of Kisii, Governor Simba Arati, on that issue, Mr. Speaker. Mr. Speaker, number 4 is, even as you do this human and we need an organization, organogram. That's a very big English word, Mr. Speaker. Organizational, that is Kiingereza kubwa kubwa. With your indulgence, of course, Mr. Speaker. Organogram, or the organizational structure of human resource, of the county human resource. Because we want to see the human resource policy of Garissa County, Mr. Speaker. Number 5, Mr. Speaker, is on the issue of wage bill. The chair has captured. I don't need to belabor that point, Mr. Speaker. The last 2 points, Mr. Speaker, is on the chief officer, Mr. Speaker, and as a house. You know, Mr. Speaker, the other day we were fighting. The majority leader was leading us to push for more resources to counties. We wanted 465 billion to go to counties, Mr. Speaker, but we agreed on 415 billion, Mr. Speaker. We are fighting so hard. Nandi has received an increment of almost 1 billion shillings, Mr. Speaker. But we are not seeing roads, feeder roads. We are not seeing drugs in Kapsabat County Referral Hospital and other. Mr. Speaker, our roads, Mr. Speaker, even in Soba Songo ward, in Chepterwai ward, all the wards that you have Nandi, Mr. Speaker, we are not seeing that value for money. Yet we fight here, Mr. Speaker. We fight very hard, Mr. Speaker, to ensure that, but you see, Garissa County government must be called to order, including led by Governor Natif Jamba, that how do you get 10 CCMs and 30 chief officers? It is not even justifiable. We need to see the justification why you need 30 chief officers against 10 CCMs. And this is bad manners that we discourage counties, Mr. Speaker. These are people. The county government of Garissa and the governor is giving devolution a bad name, Mr. Speaker. Because whenever we want, and I remember, Mr. Speaker, in conclusion, I was chit-chatting with a number of members of National Assembly who are my proteges in legislative arena, Mr. Speaker. And they were asking me, why don't you pass the CDF? Because CDF can be seen. They said in Kiswahili with your indulgence, mambo ya CDF inaonekana kwa ground. But why don't we see the money for counties? It is because of such bad manners, where you are hiring 10 CCMs and 30, and this must be stopped. Number 5, Mr. Speaker, which is very important. Who was withdrawing and who was making financial requisitions in Garissa County? In Garissa County, Mr. Speaker, in Garissa County, who was doing the financial requisitions that were being done in Garissa for those many months, Mr. Speaker? We need to be told, Mr. Speaker. We need to be told. I want to conclude,
just
Mr.
a
Speaker.
minute, Senator Chalagay. What is your point of order, Wakili Sigay?
Senator
Mr.
Wakili.
Speaker, I rise past one to Standing Order 92. I do not know whether you heard the Honorable Senator Cherargei speaking in a language that does not belong to this House. Mr. Speaker, he said, Otore. And Mr. Speaker, that is not a language that this House has.
I thought that is not English. You know, sometimes is the way he pronounces some English ones.
Mr. Speaker, with your indulgence,
Anytime you use any other language,
I didn't use
then
Mr.
you
Speaker
must
unless
also
it escaped my.
explain what you have seen.
Mr. Speaker, maybe Mr. Speaker, with all injustice, I think Senator Wakili Hilary Sigei must be, you know, he thinks in Kipsigis or Kalenjin fast before translating to English. So I allow him to do that, Mr. Speaker. Mr. Speaker, in conclusion, because I was making very pregnant point on this matter, Mr. Speaker, on the issue of requisition, we want to know who was doing financial requisition. Mr. Speaker, there is a possibility of financial misappropriation in Garissa County government within the month of 2023 and July 2024 when the accounting officers were in office. Mr. Speaker, I want to tie it with a comment that we need also, you know, the CCM argued that they had power to designate accounting officers. Mr. Speaker, you and me, that when you are an acting officer in office, your power should be limited. And I think we need to amend the PMF Act that the CCM do not have power to appoint an acting accounting officers because those people are prone to violating and abusing the Constitution, and you cannot hold them accountable because they were just acting. They can say we need to limit the powers of acting in offices, Mr. Speaker. Mr. Speaker, for the convenience of the House and with the respect of the House, Mr. Speaker, and with your indulgence, allow me to pen off by saying that this is a good motion. This is a learning curve for most of the counties, and Garissa County government must be called to order. They must follow the law so that they don't risk the impeachable offenses under Article 181 of the Constitution 2010 of Kenya, Mr. Speaker. With those many remarks, I beg to second, and I thank you.
Thank you, Honorable Senators. I propose the question that the Senate adopts the report of the Standing Committee on Devolution and Intergovernmental Relations on its inquiry into the state of governance in the county government of Garissa, arising from a statement sought by Senator Abdi Haji, MP, laid on the table of the Senate on Wednesday, 28 May 2025. Honorable Senators, you know we made a resolution this afternoon, or now we are moving this business. But I first want to confirm, under Senator Medu, to confirm whether you have quorum so that I can put the question. Senator Tams, ring the quorum bell for 5 minutes. Once they come, then you can stop. Honorable Senators, let me now put the question. Honorable Senators, I put the question that the Senate endorse the report of the Standing Committee on Devolution and Intergovernmental Relations on its inquiry into the state of governance in the county government of Garissa, arising from a statement sought by Senator Abduhaji MP, laid on the table of the Senate on Wednesday, 28th May 2025. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.
Order number 15, the Technopolis Bill, National Assembly Bill number 6 of 2024. Second reading, resumption of debate.
Senator Samson Chalagay has a balance of 15 minutes. Okay. Therefore, if you wish to spend them, you have the floor.
Thank you, Mr. Speaker. I think by the time the House rose on this Technopolis Bill 2024, I want to say as a member, Mr. Speaker, I know you might not be aware that I'm a member of ICT committee, having served for some time, Mr. Speaker. This is a Technopolis Bill of 2024, the National Assembly Bill number 6 of 2024. Mr. Speaker, in the principle of reciprocity, I wish in future the way we fast track the National Assembly bills with a lot of indulgence, they must also show the same energy and passion. So Speaker, we need to start a passionometer, because the passionometer of Senate in National Assembly bills is very good, Mr. Speaker, and therefore I want, as I suppose, Mr. Speaker, the definition of Technopolis bill is very and I know we serve together with Senator Beatrice Ogola in the ICT committee, and I know, Mr. Speaker, there are many of delegations of students. Technopolis is where it is like a Silicon Valley in the United States of America, where there is technology, the innovation, Mr. Speaker, and many others, Mr. Speaker. We focus solidly on the issue of technology, Mr. Speaker. I know these generations who have, even some of them, we are visitors, and a number of the table of clerks, apart of course from senior Mohammed, a number of them has been born in a technology era, including you as truly, Mr. Speaker. So the passage, and we had a big push and pull. I remember Senator Karen Nyamu at some point wanted to propose a bill on artificial intelligence. And the position then, in my own opinion, thank you. I don't know, when I mentioned Senator Karen Nyamu, the microphone went off. And she wanted to bring a bill of artificial intelligence. And at that point, Mr. Speaker, we were of the opinion that you cannot regulate AI. Artificial intelligence is a moving target. The technology of today, by tomorrow, is obsolete, Mr. Speaker. So I think, Mr. Speaker, on this Technopolis bill, we must be in place to ensure, Mr. Speaker, that we focus. The only problem, I have seen a number of problems, that allocate land to investors in a Technopolis, Mr. Speaker. I don't see it makes sense. What business does Technopolis have to do with allocating land? Mr. Speaker, this should be struck off, Mr. Speaker. Then establish and manage science parks, information, communication and technology parks and innovation centers. I agree, Mr. Speaker. I have met a young people, Mr. Speaker. I had opportunity over the weekend to partake a visitation ceremony of world champion parents of Amos Kipruto in Toulon, a place near Kona in Toulon, Mgwen sub-county. And I met a number of artists led by Mr. Israel, Jose, Jantex, Mr. Speaker, amongst MC Masir and the list, and a number of them, Mr. Speaker. And their concern is on how to access the revenue. But also, they were happy that the President William Ruto's government has done monetization of digital content. I know that they are able to sell. So we need to expand the technology aspect, Mr. Speaker. And that is why, even as we rule out the issue of allocation of land, under the Constitution is the work of National Land Commission. So the drafters of this Technopolis bill must delete, or as a Senate, when you go to the committee of the whole, the Technopolis authority, development authority, does not have business to do with land. Land is managed on behalf of the county and national government, Mr. Speaker. As you are aware, on the chapter of land is National Land Commission. So, Speaker, on the management of managed science parks, I have told you, most of your visitors on the public gallery who are students and people, Mr. Speaker, most of them are using into innovation, science parks and technology parks and innovation centers. I am happy, Mr. Speaker, as we talk, President William Ruto's government has ensured that at least every 290 constituencies have digital hubs. Those digital hubs, Mr. Speaker, are being used to apply for Kazi Maju and also for innovation, innovation agenda within. So these digital hubs will cover 290 constituencies across the nation. This will give opportunity to young people, including opportunity to Meru County youth, in most of those digital hubs, to do their job online, to work online, to do the innovation, Mr. Speaker, and many others, Mr. Speaker. This issue of patents, Mr. Speaker, I know with innovations, we must be careful. There are many innovations that are happening day in and day out, Mr. Speaker, through Kemri, through Calro, Mr. Speaker, and many other aspects, Mr. Speaker. They must be given patents, Mr. Speaker. With the current era of artificial intelligence, Mr. Speaker, and I had an opportunity to attend last year the World Governance Forum, Internet Governance Forum, Mr. Speaker, in Saudi Arabia. And our conversation is how do we protect issues of patents against artificial intelligence. So I know there are many young people who are innovators, who have done innovations. We need to ensure, and I'm happy the minority leader is in the House, the retired Justice, Stewart Manzayo, is conversant, Mr. Speaker, on this aspect of putting in place to ensure, Mr. Speaker. The issue of science museum, I'm happy. Let us know what we have innovated as a country. Mr. Speaker, we have been so into the past on issues of synjatrovas and anthropotrovas, the issue of mankind, Mr. Speaker. We have been arguing. We have the first mankind in Turkana. We have the Museum Society of Kenya, Mr. Speaker, and I'm happy to see Senator Sifuna in the House, Mr. Speaker. I was in Kandui constituency, where Senator Sifuna comes from, and I want to confirm to him that courtesy of subsidized fertilizer, the maize in Kandui constituency, Bungoma County, where Senator Sifuna comes from, is doing very well. And I can assure him for food security and availability of ugali going into the future. With, of course, indulgence the use of word ugali, Mr. Speaker. Mr. Speaker, and therefore the issue of museum. I know we have traveled to Jeoyet, we have gone to Turkana, we have museum. I know the students who are your visitors on the gallery will now visit museums. But we want to create science museum. You know, they are no longer excited. These visitors of viewers up there who are students, they don't care about synjatrovas and trophoras or those mankind. They don't want to care about the original mankind. They want to know what technology is doing for them. And this is a digital era generation, Mr. Speaker. We want to build a digital economy, even through M-Pesa and many other aspects, Mr. Speaker. And then the investors, I agree we need to get more investors, Mr. Speaker, like Meta. We need TikTok, Mr. Speaker. We need, and I remember, Mr. Speaker, we had a slight problem with TikTok. I'm happy, and I want to thank the Communication Authority of Kenya, led by Director General David Mugonyi, for coming with a proposal that all the international must come to Kenya, must establish physical offices. Twitter, which is now called X, Mr. Speaker. We have Meta, which is right on Facebook. TikTok, Mr. Speaker, and all, even Snapchat. We need them to establish physical offices in Nairobi for easy following, Mr. Speaker. Because some of these forums are being used wrongly to mislead the young people through ban contents, Mr. Speaker, and also to incite and breach peace, national peace, Mr. Speaker. Mr. Speaker, on the issue of technology, we agree. Even in the IEBC 2017 technology, I have seen, Mr. Speaker, the IEBC chairperson and IBC are proposing a raft of legislative issues around elections, Mr. Speaker. I think as a parliament, Mr. Speaker, in my own assessment, and I've been in this parliament for some time, Mr. Speaker, I think we have enough laws, Mr. Speaker, and I know Senator Muma, who is one of the accomplished lawyers, we have enough laws to manage and run elections. I think what IBC should be doing at the moment is to lay the groundwork in terms of limitation of boundary, Mr. Speaker, in terms of ensuring continuous registration of voters, and to ensure the by-elections are done in more than many constituencies and counties that do not have representation in this country, Mr. Speaker. So the work of IEBC is well cut out. They don't need to bother the country with legislative interventions or policy interventions at this point in time. Because as a parliament, Mr. Speaker, I want to assure IEBC we have done proper legislative and policy framework that needs the IEBC commissioners to settle down, Mr. Speaker. I know they want to issue of technology. We are willing to, we have amended the law, Mr. Speaker, to ensure that we put in place the aspect of technology in terms of running elections. So the IEBC should rest easy and focus on the hardware of ensuring that we have credible, proper, and verifiable elections in 2027. And I'm happy, Mr. Speaker, to that, Mr. Speaker, IEBC now is in place. So now the focus, Mr. Speaker, the focus should be proper, Mr. Speaker. And I've seen since, Mr. Speaker, on a lighter note, as I finalize with my final point, that since IEBC came into place, Mr. Speaker, the opponents of President William Ruto have gone silent because they have realized the real game has just begun. They have now become confused than ever, Mr. Speaker. Mr. Speaker, number 6 is on the role of the county government. We need to enhance in this bill, Mr. Speaker. Let us put its focus, establish a special purpose vehicle as may be necessary for the discharge of its functions. The KRA, Mr. Speaker, I think the work of KRA is what cut out. What does Technopolis Development Authority is doing, Mr. Speaker, is not right. I want to challenge that they don't have a role. Let us leave KRA to ensure, Mr. Speaker, that they do their job because grant such exemptions of fees, levies, and any other charges imposed under this act. I thought those, Mr. Speaker, I'm proposing 2 things. KRA should be left to do its role. And number 2, Mr. Speaker, we normally finance bill every financial year. I want to challenge, Mr. Speaker, that these finance bills must and should be passed, Mr. Speaker, should be allowed. They don't have the power to exempt. The Constitution and Article 210, the imposing of taxation is an exclusive domain that is provided through legislative intervention. Mr. Speaker, let's allow the finance bill to be the one to take care of exemptions or taxes or any levies imposed under this act, Mr. Speaker. Mr. Speaker, even I'm happy with technology because now as we talk, Mr. Speaker, across the country, and Kenya alongside South Africa, Mr. Speaker, are one of the countries that are accessing technology. Mr. Speaker, and therefore I'm happy to report that under President William Ruto's government, Mr. Speaker, 24,000 fiber optic cable has been laid across the country. This will ensure accessibility of internet. The only problem I have, Mr. Speaker, and I know the ICT committee, in conclusion, the cost of internet charges in this country is still very high. The Safaricom, the Airtel, and other even Telcom, Mr. Speaker, the cost of internet is still very high. The cost of bundles. Mr. Speaker, whenever you buy, for example, under Safaricom, you buy a bundle of 999 shillings. You get 10 GB. Mr. Speaker, why does it have to expire after 7 days? Yet it is something you have bought it. Mr. Speaker, there is something, we must reform the issue of internet, Mr. Speaker. Because when I buy 10 GB for almost 1,000 shillings, why should it expire and it is my bundles? Mr. Speaker, Safaricom and other agencies must be called to order. There should be no expiry on something you have bought, Mr. Speaker. And I'm happy the Deputy Party Leader of ODM is here and is very passionate on issues of ICT, Mr. Speaker. Senator Utsosi and my good neighbor of Vihiga. We should be told, why should data expire? Yet you have bought it, is yours, Mr. Speaker. Whenever you buy maize, because we grow maize, I give you 10 bucks. It should not expire, Mr. Speaker. The goods and content services should remain as is, Mr. Speaker. In fact, with the laying of 24,000 fiber optics across the country, the access to internet should be very careful. Mr. Speaker, I want to report under President William Ruto, we have 1,494 Wi-Fi hotspots for Mama Mboga and Boda Boda to access Wi-Fi wherever they are. Mr. Speaker, since President William Ruto came to eCitizen, which is part of the ICT, more than 22,500 services have been shifted from 353 services before the President came into power, Mr. Speaker. And this through online, because we are discussing about technology. More than 300,000 youth have been taken through Ajira program, courtesy of the ICT, alongside 290 digital hubs, Mr. Speaker. Mr. Speaker, I want to confirm to the House, out of 404 proposed digital hubs, 316 operational digital hubs has been put in place under President William Ruto's government. So the point I want to prove in conclusion is that this Kenya Kwanza administration and the broad-based government is very keen and in support of technology in this country, Mr. Speaker. We want the young people to get access to technology. We want the internet to be affordable. We want, Mr. Speaker, you remember in 2022 elections, there were constituencies that there was no network coverage. When we were in Mandera, Wajir, Turkana, Garissa, we still have a problem with network coverage, Mr. Speaker. Why? Because of terrorism, even in Lamu. Terrorists nowadays, Mr. Speaker, are targeting the masts. The mast, Mr. Speaker. They are targeting the mast of the... We need the SIPU. Mr. Speaker, there is a unit in police called Critical Infrastructure Police Unit. It's called SIPU. Critical Infrastructure Police Unit. They must protect this mast that due for network coverage, Mr. Speaker, so that the people of Mandera, Wajir, Garissa, Marsabit, all the way to Turkana, even to some parts of West Pokot, Mr. Speaker, even to finish the issue of cattle rustling and banditry in Kerio Valley, Mr. Speaker, is to ensure there is proper network coverage in Kerio Valley, in Baringo, in Samburu, even in other areas that are suffering from insecurity, by ensuring that there is accessibility of technology. Mr. Speaker, you remember I did bring an amendment of Cancer Prevention Act. One of my proposals was use of telemedicine. It doesn't make sense, Mr. Speaker, to have a cancer patient or our patients traveling all the way to India to get medical care. One, we are losing resources, taxes. Number two, we cannot hire enough doctors. Mr. Speaker, why don't we use telemedicine, courtesy of this technology? You are somewhere in Vihiga, you are somewhere in Kisumu, you are somewhere in Lamu, in Homa Bay, in Nairobi, in Kilifi, in Nyamira, Mr. Speaker, in Nairobi, you are in Meru, somewhere in, not Katwana, Katwana is in Taraka, in Makutano, Mr. Speaker, where I think Antibaiju, where we went with you, Mr. Speaker, why don't you go to a hospital in Meru, in Kapsabet? Use telemedicine, Mr. Speaker, because I've seen my time is spent. Allow me, Mr. Speaker, I was getting hotter and hotter, but allow me to support this bill and say there are a few amendments we need to do, Mr. Speaker. With those many remarks, I support with amendments. I thank you, Mr. Speaker, sir.
Senator Chalagai, I can see in my notes that you are supposed to second this. So can you pronounce yourself? It's not?
Yes, it was seconded.
The misdirected by Mr. Mogere, who is in charge of. So then let us have Senator Karen Nyamu contribute. I open the motion for debate. Senator Sosi seconded.
Thank you, Mr. Speaker. I rise to support the Technopolis Bill of 2024. Mr. Speaker, Kenya is not short of tech talent. Our young people have already done exploits in this field, and that's including the young man who came up, who innovated the mobile banking, comes from our country, and many others that our young people have been able to do. We only lacked an ecosystem to enhance it and to have our young people do their talent in an organized and in a profitable manner. So this bill is a good step and a bold one towards remedying that. It also creates other technopolises far from Konza, because we know that the Konza Technopolis and the Konza city was seen as the breakthrough of tech in this country. Mr. Speaker, for far too long, Nairobi was thought as the tech hub. But this bill proposes to democratize or to devolve Technopolis, or tech for that matter, because it proposes other technopolises around the country, from Kisii to Wajir. And we have to ask ourselves, how will these sites be identified so that we are careful not to introduce tokenism when we are picking the sites, so that if you come from a marginalized area, then you are out of luck. Mr. Speaker, this bill also proposes to streamline bureaucracy so that we don't have to go from one office to the other, our young people with brown envelopes with many documents. It proposes one permit, one system, and so that will tackle the issue of bureaucracy. The bill also aligns with President Ruto bottom-up policy, so to speak, because what is bottom-up if not to give the Mama Mboga son an opportunity to also be supported in tech and in their talent. Mr. Speaker, we also have to ask some questions, because this bill has been done in such a way that is hostile to counties. Because how do you ask a county government to support you with land, infrastructure, and all that, then you deny them a seat on the table? Nairobi, for example, has had 100 Technopolis or tech hubs registered without this proposed centralized body. And so that is to show that is not really what we needed. We just needed a devolved innovation framework for the country, so that county governments are very involved in it. And I think that is something that we can come up with as we go, and we can have amendments as we go. But most importantly, let us pass this bill. As a mother and as a leader, and a witness of what tech can do to pull families out of poverty, we need to pass this bill and give our young people an opportunity to turn their dreams into jobs. Thank you, Mr. Speaker.
Senator Catherine Mumu.
Thank you, Honorable Speaker, for the opportunity to speak to this bill. Honorable Speaker, I am wondering whether this is a necessary bill. Honorable Speaker, sometimes I get frustrated by bills that come from National Assembly. Many tend not to align to the constitutional framework that we have, governance framework, that is the devolved governance system. Honorable Speaker, reading through this bill, I went straight to clause 5, which lays out the functions of this authority that is being established. And the first question I asked myself, is this authority necessary? We need to grow the digital technological economy and digital economy in Kenya, but does that require an authority in order for that to happen? And the answer is no. When you look at the fourth schedule, we don't have digital technology as an assignment or a function of the national government. Neither do we have it as a function of the county government, simply because digital technology is an enabler of functions, which means both national and county governments need digital infrastructure and technology to carry out their functions. So if you're talking about businesses, if you're talking about establishing industrial parks, which national government in fact is facilitating in terms of additional allocations and conditional grants to counties, counties are setting up spaces, and nothing in law stops a county from establishing a technopolis if it elects to do so. So a law like this one is actually misleading, because it makes it look like for you to establish a technopolis in Kisumu County, you need some authority to come and tell you how this operates. I beg to differ that this is another unnecessary parastatal that is just going to gobble public funds and not assist us. I am of the opinion that the Senate should be bold enough to actually say we need the Ministry of ICT to actually put in place the digital public infrastructure, lay the fiber cables throughout the country to enable every county, every space to actually develop the necessary digital technological capacities. Honorable Speaker, innovation is not a function of a national government or a county government. Innovation can happen by anyone, whether in private sector or public sector. So if we start creating institutions and give them mandates to say they are the ones in charge of innovation, you are actually creating bureaucracies that are going to inhibit those who want to move. In fact, my view is that we need to fund our public universities better. Give our STEM subjects, our STEM departments, more resources, state-of-the-art equipment to actually carry out that innovation. Because learning institutions are the best spaces to actually nurture innovation. If we remove that from the universities and say now we are setting up a parastatal, it is in charge of innovation, it is going to do research, I think we are moving in the wrong direction. Honorable Speaker, at clause 5.1a, 1b, I see that this authority is being given powers to allocate land to investors in a technopolis. I have not seen any cross-referencing to the land commission. I have not seen any cross-referencing to county governments which hold county land. I have not seen any reference to municipalities, to cities who also have mandates around matters planning. I think if we pass this law without having a proper conversation among the stakeholders around this issue, we are going to cause more confusion. Honorable Speaker, I have not seen any cross-referencing around what the Communications Authority in Kenya does. Neither have I seen any cross-referencing with the Data Commissioner, but I can see this authority is being given the mandate to actually be the one that is going to be the custodian of business data, whatever that means. Honorable Speaker, I think if we pass this law, we will actually be adding problems and creating confusion instead of enabling the kickoff of the digital economy in this country. Honorable Speaker, clause 5.1j actually gives this authority a function to undertake investment in a Technopolis either by itself or through partnership. So this is the authority that is supposed to give guidance, guide innovation, but it is also supposed to do business in competition with those who will be doing businesses there. This is a matter of conflict of interest. So is it a regulatory body? Is it a standards body? Is it an investment body? I think we are actually getting it wrong. And having said that digital technology is an enabler of anybody, private, anybody, county government, national government, I have then looked at the board, constitution of the board, and the board is full of national government PSs and people elected. It's basically being formed as a national government parastatal, being given functions that are going to be actually to go across the counties. I think whoever drafted this law did not bear in mind our provisions in the Constitution, particularly Article 6, that requires that our governance system is a devolved governance system that must actually recognize both national and county governments. So we are establishing a national government parastatal, giving it functions that are going to cross-cut to counties, and the counties do not have any role in this. My view is, if we need to set up a body like this, we need to go back to the drawing table. We need to ensure that that institution is intergovernmental, not national. We need to give it extremely narrow mandates, which would include just laying out the public digital infrastructure and leave the rest to the markets to actually grow. If you enable access to internet in the villages, the markets will grow. They don't need any authority to come and tell them how to do digital development. If we give resources to our universities, to our TVETs, we will be able to build the capacities around technology that would also enable our businesses to grow around technology. So just on the looking at the functions of this authority and the composition of the board of this authority, Honorable Speaker, this law offends the Constitution. I'm suggesting that the senators relook at it and be bold enough to tell the National Assembly we need to go back to the drawing table to do this, to ensure that this law aligns to the Constitution. I don't support it in the manner it is, Mr. Speaker. Thank you.
Thank you. Senator Wakirilali.
Thank you, Honorable Speaker, for giving me the opportunity to comment on this bill. And Mr. Speaker, from the very onset, from where I sit, from the intention of the drafters of this particular bill, I support the enactment of a law that will help us to grow, develop, manage the governance of our Technopolis. So, Mr. Speaker, I support, but with reservations on a number of provisions in this particular bill, which I will propose that the same be subjected to amendments so that it aligns with the Constitution and ultimately achieves the objectives that the bill seeks to create and advance in terms of technology in our country. Mr. Speaker, part of the larger reason why I support this bill is that the development of ICT hubs across the country, which is one of the projects or programs that the Kenya Kwanza government had in its agenda to the people, is to ensure that we utilize the growth and development of ICT in ensuring that our young generation, Kenyans who are tech savvy, get a benefit of using technology in order to not only create employment, but to earn a living, develop their business ideas, and go beyond the region in ensuring that they get jobs and they utilize their expertise. Mr. Speaker, remember, Kenya is one of the fast-growing ICT hubs in the region, and this law, once amended, and with various propositions that I believe honorable members will give here, will support that idea to make sure that we position this country beyond the region, but globally in matters ICT, in matters technology, and that way we will be expanding the scope of source of employment to the people of Kenya. Mr. Speaker, I come from Bomet County, and there is a region in Bomet called Mulot, where we have high-tech boys and girls in ICT. My neighbor, Senator Okongo Mogeni, knows that when you cross over Mulot, you either switch off your phone or you place it on some flight mode because of the technology that is available there. This bill, Mr. Speaker, will ensure that we facilitate and tap to ring-fence such kind of technology to support those young Kenyans, those young Bomet residents, to make sure that we formalize their expertise in ICT and use it appropriately, rather than to enhance their utilization of that in what the law is not yet recognizing it as appropriate. And Mr. Speaker, I will comment about the Mulot ICT Hub, which once this bill is passed, the direct beneficiary will be myself and thousands of residents and techno-savvy young men and women in Bomet who will be directly benefiting from this particular law. However, Mr. Speaker, when you look at a number of the provisions, I want to go straight to some of them. For example, this is what Senator Muma has commented about, Clause 5B, where the proposed law seeks to mandate the authority to allocate land to investors in a Technopolis. Mr. Speaker, Technopolis has been defined in Section 2 to mean a zone area which has been ring-fenced for purposes of ensuring that we have got businesses, we have got transactions within the ICT zone, but then the authority has got no role in law, in constitution, to allocate land to investors without, in this particular provision, making reference to the county government, to the National Land Commission, whose mandate in the Constitution is to be involved in such matters, land allocation. It therefore means if this law passes as is, an individual will go to court, challenges the provisions of Section 5(1)(b) as unconstitutional, and we will lose the important provisions which are compliant with the Constitution, but for this particular provision. Mr. Speaker, I therefore propose that that particular clause be amended to ensure that it aligns with the Constitution by making appropriate references to other institutions mandated in the Constitution and law for land allocation. Secondly, under the same clause 5F, this is clause 5(1)(f), Mr. Speaker, this is what I earlier on said. The role or the mandate that this authority is given is to facilitate realization of Kenya's digital economy by use of emerging technologies to support business within a Technopolis. Mr. Speaker, as I said, the Kenya Kwanza Plan had the provision of establishment of over 290 ICT hubs, meaning each constituency, in fact, has been required to provide beyond the constituency to the ward, where there should exist a hub, ICT hub in such a place. Mr. Speaker, this in itself will ensure that we cascade the provision of ICT technology, opening up opportunities not only in the 290 constituencies, but in almost each and every ward, thus ensuring that we facilitate the realization of the Kenya's digital economy which of course, Mr. Speaker, is one of the major source of business opportunities and economy, which economy is built on job creation and marketplace for almost every other aspect of that we do because of the emergence of ICT in the world. This is a very good provision, and I support to the extent that it feeds into what people had been promised whilst this government was seeking to be given an opportunity to serve for this period. Similarly, this will ensure that, of course, whenever we have all these Technopolis, there will be a one-stop shop. When you look at the mandate of this authority, opening up all sorts of business opportunities which are supported by ICT in one area will ensure that we have got a one-stop shop. By extension, we limit the abuse or rather the misuse of opportunities because you will be able to do and transact within one area because of all businesses that will be operating within that the Technopolis. Mr. Speaker, the provision of the proposed clause 6 on the membership. This is actually clause 6, Mr. Speaker, talks about the authority to have certain powers. Among the powers are what I've said, which are unconstitutional, but specifically under 7, the creation of a board to manage the authority, particularly under clause 7E. Other than, of course, the chairperson to be appointed by the president, there is a requirement, as it has been said by Senator Muma, this is an intergovernmental function. We are creating Technopolis not only at the national level, we are creating Technopolis, and therefore there should be some relationship between the national government and the county government. Among the 9 members of the proposed board or authority, 4 of them represent the national government, and 7E represents 5 persons who the clause seeks to be appointed competitively by the cabinet secretary. Mr. Speaker, unfortunately, there is no reference at all to any representation of either the Council of Governors or the county governments where such Technopolis are to be domiciled from. Mr. Speaker, that is one provision that is very critical. It will not be possible for an authority to be representing certain functions which are devolved in law, and yet there is no representation in the board of the county governments or the Council of Governors. And so, Mr. Speaker, I propose therefore that there should be further amendment to clause 7E so that among the 5 people who will form members to the board who are supposed to be competitively recruited, they must be ring-fenced to represent the county governments. If not all of them, at least 3 of the members who will be competitively recruited must be members who will be appointed or nominated by either the Council of Governors or the respective county governments that such a Technopolis will be domiciled from. That way, we will be protecting the interests of the counties as well as ensuring that certain functions devolved are not only performed exclusive by the national government, but with the involvement of the county governments. The rest of the requirements on the qualifications, experience of these individuals to be nominated is provided for under 3B, which, Mr. Speaker, ensures that there will be a diverse character of personnel that will be represented in the board. That way, we will be having everyone from among engineers, architects, physical planners, ICT experts, law, social sciences, and other relevant fields. This way, we will be able to have diverse representation within the board, and we will tap those experiences to make sure that we maximize the people who will be dealing with the management of the board. And lastly, on this particular one, Mr. Speaker, the appointment at different dates, this is provided for under clause 7.5, is to ensure that not all the 9 members who will be sitting in this board are appointed at the same time. There is a proposal to stagger the appointments, and this, of course, is aimed at ensuring that there will be no time or no period within which all members of the board their term is expiring at the same time. That way, we will ensure that there is continuity. When one member's term expires, the remaining members in the office can be able to run, and therefore we do not have a lapse in terms of the history, in terms of the perpetuity of the office. The staggering of appointment and nomination of members is welcome, and Mr. Speaker, this will ensure that we achieve what we have across the board made reference to continuity of office. Under clause 18, Mr. Speaker, the clause provides that this authority is expected to collaborate with relevant county government or any other government entity. This is where we are saying it is going to be extremely impossible for the authority to purport to coordinate and liaise with relevant county governments for purposes of collaboration on development of this Technopolis or in any other manner that requires that collaboration when there is no representation in the board of either the Council of Governors and the Council of Governors or any other person representing county governments. This Section 18, Mr. Speaker, will prove to be extremely hard to implement, and therefore it calls upon this particular bill to be amended to ensure that we give them that room to have representation. As I earlier on referred to the ICT hub that is to be developed in the county of Bomet-Mulot, it is the county government of Bomet that is required to provide for the land, and that, Mr. Speaker, has actually been made available. It will not be possible for the national government, whether it's Concert Technopolis or any Technopolis for that matter that will be created if this bill were to be passed, to go down to Bomet, develop infrastructure, get certain approvals, and the county government is not involved. So the provisions of clause 18 all the way to 21 are very critical to make sure that any expected collaboration achieves the objectives of this bill. Without such amendment, it will not be possible because it is not going to be easy for the national government to run without having the support of the county government. Under Part 5 of this particular bill, it's under Technopolis Development Control. This is the same challenge that will come to the development of the control mechanism of the Technopolis in the absence of county governments. There is no clarity under clause 23 on how this control will be achieved, because you cannot expect the authority to regulate zoning, especially where the county government is not involved. There is need to ensure that by the time we are giving the mandate to the Technopolis to control zoning, the county government have a role to play so that whatever zoning that is going to be expected to be done, it is done in full collaboration with the relevant county governments, or representatives of the county government will also, of course, be able to support such particular zoning. The provisions of clause 25 make specific reference to application and approval of development permits. Under this clause 25, there is no reference at all to any role that any county government were to play. Mr. Speaker, remember, our county governments have got the mandate in law to issue certain permits. It will not then be possible for the Technopolis or the authority to grant licenses where there is no reference to any role to be played by the county governments in licensing, in approvals, or in cancellation of those licenses. Yet, it is one of the major sources of revenue for the county governments to issue licenses to businesses, to issue permits to businesses and related roles. So we will need to still relook at the provisions of that particular clause 23 with regards to licensing. Under Part 5, this is Part 5 on licensing procedure, Mr. Speaker. Clause 29 provides that Clause 29 and Clause 30, they speak not at cross-reference, but contradicts each other. these two clauses needs to be relooked at so that there is compliance in how one is required to apply for license and how that application in terms of whether we are classifying the licenses, where we are giving a certain fee to certain licenses. Clause 29 and 30 should be able to speak to one another so that the law can flow. But specifically under 29C, where it gives a very blanket authority to exempt certain applications from getting licenses before they operate, Mr. Speaker, I propose that the authority should only be allowed to grant exemption on two of the three proposals made. One, if you are a startup business enterprise within the technology and you are on your initial operation stage, you can be exempted if you meet the qualifications as shall be established in the regulations. And secondly, if you are undertaking a collaborative or research partnership with an already licensed and existing entity within the Technopolis. The provision that is proposed to grant another condition of any other person as may be provided for by the authority, by the regulations, is an abuse or a possible abuse of this particular provision in law. We do not need to provide for this in the Act. If necessary, if it must be there, it can only be placed in the regulations which the Cabinet Secretary is mandated to process and prepare for purposes of application. But if we leave this as is, Mr. Speaker, it is prone to a lot of abuse. Lastly, Mr. Speaker, the bill, as I said, is a good bill. It is a bill that its time has come. It will open up the region, the country to the region, and also will facilitate what we are all aware of, because where we are right now, we are in an IT world. Everything else is on the platform of technology, and this bill will ensure that it gives us the support that we require to transition. And as it transitions, if the objective of the provisions of Part 11 on the transition and the saving clauses to maintain and protect the former authority, in this case, Mr. Speaker, this is the Konza Technopolis Development Authority, a number of provisions in the proposed law needs to be relooked at so that we transition appropriately from Konza Technopolis to other technopolis across the country without necessarily hampering the right of a county to establish its own technopolis, because as it is, it will mean that a county government can or is actually not in a position to develop its own without referring to the authority, without getting the approval from the authority. And as I've said, there is no representation of county governments through either the Council of Governors or any other representation in the authority. Mr. Speaker, with those many remarks and the proposed amendments, which I hope the committee, unfortunately, Mr. Speaker, I have not seen the chairman of this committee in the House. I hope the members who are members of that committee have followed up the proposals by members on possible necessary amendments to be made on this bill so that it be passed and it serves the purpose that was aimed at. Otherwise, as is, Mr. Speaker, there is still a lot to be done to make sure that this bill is a representation of the desires of the Technopolis and those who have come up with this particular bill. Mr. Speaker, I thank you and I support.
Very well. Senator Veronica Duarte.
Thank you. Thank you, Honorable Speaker, for the opportunity to contribute to this very important bill. From the very onset, I think the intention of the proposal of this bill coming from the National Assembly was intended to regulate a field, the field of technology, which is emerging and which is developing at a very fast pace. So the intention is good, but the bill needs a lot of panel beating in many respects because there are certain provisions that seem to usurp the powers of other entities that have certain responsibilities towards the public or towards the sector. Let me from the onset indicate that with the enactment of this Technopolis law, ideally I would expect that whatever bill is presented to Parliament, that first it encourages innovation in technology and encourages emerging expertise to be utilized in cybersecurity because of the emerging issues that we are having with technology. The bill must also meet the objective of incentivizing investment into the field of technology. If that bill is not meeting that objective, then it will be falling behind what is expected for this bill to meet. And this bill, from my thinking, must also offer a framework that attracts a lot of investments while taking into account a deliberate utilization of Kenyan human resource. Because we very well know that our young generation in Kenya are very suave in technology matters. They have advanced to a very good extent. And it would defeat purpose for us to create a law which doesn't take into account deliberate utilization of that human resource, the Kenyan youthful human resource that is very well versed in technology. I have looked at the provisions that are in this bill, and I want to join my colleagues, Senator Kathy, and I don't remember, there was another senator who also, I think it was Senator Osoti, who also talked about the definition of a geographical area, controlled area. And there is also Senator Sigei who's spoken into it. And I'm looking at the definition section, the interpretation section, preliminary. That's on page, the first, I think it's page, I don't know why it's named as page 113. I'm looking at it and asking myself why Konza Technopolis was defined with specific reference, specific parcel of land, and with a specific geographical zone, with specific hectares, 2023.6. Supposing tomorrow, Mr. Speaker, supposing tomorrow Konza Technopolis needed double this space, or did not need this much land, and needed to utilize a quarter of this land, would it be smart to define that parcel, specific parcel of land, land reference number 9918/6? What is the purpose of introducing a specific? This is legislation. This is not a contract. You define acreage and you define area based on a specific contract between contracting parties so that it locks the subject matter of that contract. When I look at definition of Konza Technopolis, it's a bit, it's something that anybody would put in a schedule or in a regulation or in an next document. Ideally in law, you must create a principle which gives the parameters around which an issue is being enacted for a regulation or a rule. So I think it's a bad idea, and that must be amended. Then I've looked at the reference to the buffer zone, meaning a defined area surrounding a technopolis that is subject to controlled land use. When we talk of a buffer zone, it is not even defined whether it's now within this Konza Technopolis or whether that buffer zone will be taken beyond the 2023 hectares. It is not defined whether the authority, Technopolis authority, will wake up one morning and define the buffer zone as a radius of, say, 1,000 hectares around the Konza Technopolis, and that leaves it vague and subject to abuse. I would say, first, when the buffer zone is introduced within this legislation, what is the purpose of that buffer zone? What is the size of that buffer zone? What does it intend to fulfill? Is it helping the Technopolis? Is it radiation? Is it subject to certain things that could be affecting the neighborhood? What is the buffer zone for? If you just throw words here, we know how our nation operates and how our people think sometimes. Some of them are not well-intentioned. They will misuse that area, that reference to buffer zone, to bring in demands on maybe the people who live around the Konza Technopolis, and it could be used wrongly by people who are not well-intentioned. So I would say, let the buffer zone be taken out. If it's not taken out, define the purpose of that buffer zone, the size of that buffer zone, whether the buffer zone is within the Technopolis area or whether it is not. And I give this submission while respecting the fact that ideally this Konza Technopolis should not be defined the way it is. This doesn't look like good draftsmanship. Then the definition of Konza Technopolis, though I'm not an expert in IT, I'm asking myself, should a Technopolis dealing with technology, dealing with virtual spaces, should it be defined in a physical manner? Or do we define even virtual spaces where this technology will be utilized? Are they within, is this act applicable to virtual spaces? So I'm thinking there is just something not correct about that definition, and experts must be able to tell us. For instance, when you have a virtual space, do you own that virtual space? Are there rights that could help one to own that? If you leave those virtual spaces here, can you raise a claim against a competitor who comes in to use your virtual space? I see many times, Honorable Speaker, when companies like Safaricom host masses, they have satellites, they have masts. I see them having a joint cooperation with other companies in the same sector in communication, utilizing that space because of certain policies that you regulate, how even those spaces, even those aerial spaces can be utilized by companies to ensure that you're not spreading out certain parameters of uses of land that could be co-shared between even competitors. So when we see the definition of Konza Technopolis as actual land, is a mindset still in investment on physical property, physical tangible assets, physical immovable assets, or do we have spaces that are not seen, by bare eyes? So I see as though that is not very progressive. It does not take into account the utility of virtual spaces. And I believe this should be amended or removed from this revised and dropped. And based on whether virtual spaces should be included, then the definition must change. Then, Honorable Speaker, I have gone to Section 5 of this bill, and I have looked at 5(1)(b), and the powers that are given to, the functions that are given to the authority to allocate land to investors in a Technopolis. From the plain reading of this provision, Honorable Speaker, this clause does not indicate whether there are any terms even for allocating that land. And indeed, as pointed out by legal experts who are also dabbling in as senators, land allocation is something that is not within the purview of the Technopolis unless if they own it and they want to lease it. In which event, they would say leasing the land or using different terms and concepts. Allocation of land is a function that is left to either the government, the Ministry of Lands, or county governments. They could allocate, but I'm not sure whether allocating land is a concept that should be used here. Maybe other definitions of how land could be, how land could be leased out, or other ways or licensing of that land by the holder of the title. And again, the provision leaves it very open. For instance, if this is enacted into law and it says that this authority shall allocate land to investors in a Technopolis, it means all I would need to do when this turns into law, I would just walk into the offices of the Technopolis authority and then demand that land be allocated to me. And because they have not put it subject to any conditions that may be developed by the authority, I would even say it's a free allocation. So if you try to put a premium on it or demand a consideration for that land as the authority, a person interested in that land or an entity interested in that land could easily challenge this in court and say it was an open allocation. So if they must allocate or lease out this land, that must be amended to read that based on the conditions that will be laid out by the authority. It has to be closed so that anybody transacting with that authority will understand that there are conditions that are developed. And then there is the concept within which this law has been made. If you read it, it's pointing at just the Konza Technopolis. How about the concept of this Technopolis being open to 47 other counties? So that we have a clause introduced in the bill foreseeing a situation where the 47 counties would have the freedom to also develop their own Technopolis. And supposing already in one of the counties, say in Nairobi, they're already having an area where Nairobi County, where they have already developed a concept close to Technopolis. Can a clause not be introduced into this bill that then says those Technopolis which are already meeting the conditions under this bill will be recognized to be within the purview of this bill and will become subject to the authority? The land use in the Technopolis, there is defined in section 6 of this Technopolis bill that the authority shall have all powers necessary for the proper performance of its function under this act, including the power to regulate land use in a Technopolis. So how far do you give this power to Technopolis, and why is the land use being regulated by Technopolis while in actual fact the zoning of land and land use is defined elsewhere, especially because there is an intention for that land to be allocated? I think this is an overreach and it needs to be redefined. That function could be resting elsewhere, not within the Technopolis. And if they must do it or give an advisory, they can only give an advisory to the organs or the entities that are legally mandated to deal with the land use planning. So my submission is that function rests elsewhere and should be left to the entity, the public entity that is supposed to deal with it. When I look at 6D, approve development applications, issue construction permits, and license users within a Technopolis. Of course not, they cannot issue construction permits. That once again is within the purview function. It's a function of the county governments. They issue construction permits unless they need a very technical construction permit whose expertise rests within the Technopolis. But there is no suggestion within this bill that they will have a team of experts in construction of premises suitable for matters that are required to be developed or technology that requires to be developed within the Technopolis. They have not brought in the element of very special expertise that cannot be handled by the county governments. And if they have not brought in the concept of experts who can come into these construction permits, that is not within their mandate. So it will be void, even on the plain reading of it. And they do not reference to any regulations that will be applied in licensing. Then I want to look at 6F. The authority has been given powers to enter, inspect, and search any premises to enforce the act. Is that not going against the Standard Policing Act? How will they enter? Do they have a policing unit? Is there a creation of policing unit? It's food for thought to the proposer of this bill. Let me go to the qualifications of the chair and under section 7. The chair seems to be a person qualified for appointment as the chair if the person is a citizen of Kenya, holds an undergraduate degree from university recognized in Kenya, has at least 10 years experience in leadership and management, and meets the requirements of Chapter 6 of the Constitution. I do not think those qualifications are adequate for a chair of such an authority. We must add another qualification, and an amendment must be done to this section to add that he must be a graduate qualified in a matter of technology, so that he's versed with what the authority is doing. Just bringing in somebody from, for instance, if you gave that authority to Professor Tom Ojienda, and we know what his expertise is in, would he be the best suited Kenyan to lead that authority? My proposal is it should be a person who is versed with IT or technology matters or communication matters. So, Honorable Speaker, in my view, a lot of work needs to be done, and a lot of work needs to be done to amend and revise these sections. This looks like an ordinary bill, one that does not go into the specializations that it is supposed to be addressing. So while the intention is good, it does not go into the specific technology area and bring out the salient, unique issues that need to be addressed within the Technopolis. And once again, the buffer zone of the Technopolis needs to be addressed. That concept of the buffer zone needs to be addressed. And then, Honorable Speaker, I've seen a section also requiring that processing of expatriates' permits, working permits, will be done by the authority. That also needs to be rethought. Processing of such permits would normally be done by the immigration, and entities that come to trade or invest must have the local content. They must have Kenyan within the purview of their human resource, so that if we have local skills that can serve within those companies, they must be included, and they must have a Kenyan local content included in any investments that come into the Konza Technopolis or into the Technopolis concept. With those many remarks, I support this, but subject to revision, to heavy revisions, to clean up and tidy out all those issues that have not been addressed, and to bringing the concept of technology within the bill, so it doesn't look like an ordinary bill dealing with any other ordinary aspects in Kenya, but it must come through as a bill that deals with AI, if AI needs to be dealt with in this bill, other aspects that are emerging within the technology, how they would be managed if they are housed or premised on the Technopolis jurisdiction. Thank you, Honorable Speaker, for the opportunity, and I support.
Okay, let's have Senator Pelis Tobiko.
Thank you, Mr. Speaker. Mr. Speaker, I rise to support this bill, Mr. Speaker. Mr. Speaker, this bill has come at an appropriate time, Mr. Speaker, when Kenya is going the technological way, Mr. Speaker. Mr. Speaker, we definitely need this bill to start and to regulate the virtual infrastructure, the virtual space, the virtual businesses, Mr. Speaker, and to initiate the issue of Technopolis in this country, Mr. Speaker. Mr. Speaker, it has been long coming because the idea was mooted during the time of President Kibaki, Mr. Speaker. And to the extent that today the Konza city has come, Mr. Speaker, it is moving in the right direction, albeit slowly, Mr. Speaker. But, Mr. Speaker, there is hope. And, Mr. Speaker, this is the direction to go. I have listened very carefully to Senator Senator Veronica. And whereas a lot of things she has mentioned do make sense in the cleanup of the bill, Mr. Speaker, but definitely this bill, Mr. Speaker, has come at the right time. A lot of Kenyans are going to depend on the virtual space for businesses, particularly the young people, Mr. Speaker, because at the moment, Mr. Speaker, the world is going the technological way, Mr. Speaker. So for this bill to start regulating the virtual space and also even the physical space, particularly of the Konza city, Mr. Speaker. Mr. Speaker, Kenya will be known as a global pace setter in this area, Mr. Speaker, of technology, Mr. Speaker. So, Mr. Speaker, besides regulating the virtual space, the virtual businesses, the online businesses, Mr. Speaker, also right now, why this bill is referring to the authority is because, Mr. Speaker, even the physical space needs to be thought about, needs to be regulated, the infrastructure needs to be put in place, Mr. Speaker, for a proper takeoff, Mr. Speaker. Mr. Speaker, at the Konza city, a lot of horizontal infrastructure has already been done. And every time, Mr. Speaker, a lot of Kenyans have been worried that the Konza city is going to be a white elephant, Mr. Speaker. But because the subsequent governments, including the even the Uhuru Kenyatta government, embraced the issue of the Technopolis, and right now President Ruto has embraced the same. I think the Konza Technopolis is going to be a reality, Mr. Speaker, and a lot of Kenyans are going to benefit. Already, Mr. Speaker, we have seen the settlement of a number of universities at the Technopolis, Mr. Speaker. We have the Open University of Kenya already settled at the Konza Technopolis. We have, there is another technological university which is also starting. I think it has started, Mr. Speaker. And so, Mr. Speaker, there are a lot of infrastructural development that are at the Konza city right now. Mr. Speaker, I know there is the data center, the nation data center already in place at the Konza Technopolis. There is a high security system being established at the Konza Technopolis, Mr. Speaker. And so I think this whole the Konza Technopolis is definitely a good startup for the future, to prepare Kenya for the future, Mr. Speaker. Mr. Speaker, there are a lot of opportunities at the Konza Technopolis. And why particularly I will not necessarily say the authority that's going to be established will only concentrate on the virtual space, Mr. Speaker. Even the physical space of the Technopolis and the developments around there will benefit a lot of Kenyans, Mr. Speaker. Actually, Mr. Speaker, for those of us who come from around the Technopolis, Mr. Speaker, because I am a neighbor to the Technopolis, Mr. Speaker, our hope of having infrastructural development around the place is now pegged on this, on the reality of the Konza city, Mr. Speaker. Mr. Speaker, a lot of people from both Machakos, Makueni, and Kajiado counties, and other Kenyans are looking at the Konza Technopolis to be an alternative city from Nairobi, Mr. Speaker. And not just an alternative city, but a well-planned city, Mr. Speaker, a city of the future, a modern city, Mr. Speaker, that has been planned, because a lot of cities in this country, Mr. Speaker, spring up from non-developed and no plans in place, Mr. Speaker. And so, finally, we have a city in Kenya that will embrace both the physical, the virtual. Mr. Speaker, a lot of planning has gone into the Technopolis, and so it is very important that the authority is put in place to regulate the development, to regulate the opportunities, and to encourage, foreign investments, and to encourage a lot of international, businesses, Mr. Speaker, to come into place. So, Mr. Speaker, I do support the establishment of the authority. I do support, Mr. Speaker, the realization of the Konza city, Mr. Speaker, because we have waited for a long time for this the Technopolis to become a reality. Mr. Speaker, the authority also will become a one-stop shop. From the layout that is there now, Mr. Speaker, you will find a completely self-sustaining city that will have everything in it, well planned, Mr. Speaker. Mr. Speaker, I believe the Konza Technopolis, once it's fully developed and fully functional, Mr. Speaker, Kenyans, it will be a place that a lot of Kenyans will want to be associated with, Mr. Speaker. Mr. Speaker, there is proposed establishment of the Science Museum, Mr. Speaker, within the Technopolis, and I think, Mr. Speaker, this is a very welcomed idea. Mr. Speaker, it is very important that a lot of things will be documented and preserved for future purposes, Mr. Speaker, for learning purposes, Mr. Speaker. I believe the authority will be able to do that, Mr. Speaker. There will be a lot of amendments to this law, as there has been for other laws, and so our worry should not be that this document is not necessarily at its perfect form, but that it can be improved. It will be made better, Mr. Speaker, right at this level and even in future, Mr. Speaker. But, Mr. Speaker, definitely, this is not a bill to oppose, Mr. Speaker, because it's taking Kenya to the right direction, Mr. Speaker. Mr. Speaker, talking about the buffer zone that this bill will create, the kind of acreage that will be around the Technopolis, Mr. Speaker. Mr. Speaker, I remember when President Kibaki had proposed that, some small structures that were around the Technopolis should be removed so that the Technopolis gets, the global stature that was intended, Mr. Speaker. Mr. Speaker, I am sure that has been taken into place, and this will protect the Technopolis from, mushrooming structures around the place that might then lower the standards of this very beautiful city, Mr. Speaker. Mr. Speaker, a lot of us are looking forward to the realization of this city in the Technopolis and the virtual systems that are going to be established. When you see a lot of young people in our homes today, Mr. Speaker, a lot of them are comfortable working virtually, learning virtually, doing a lot of things online, Mr. Speaker, and it saves time. They don't have to get stuck in traffics. They don't have to get stuck in physical offices, Mr. Speaker. Yet they will be contributing to the economy of the country, Mr. Speaker, once this authority is fully functional. So, Mr. Speaker, I support completely the passing of this bill, the establishment of the Technopolis, and the continuous improvement Mr. Speaker, and placement of Kenya as a pace-setting nation in terms of technology, Mr. Speaker. Mr. Speaker, I do support.
Now, honorable members, there is no other senator keen on contributing to this bill, and since the mover of the motion is not present in the House, I shall defer putting of the question to the next sitting, and therefore, clerk, I direct that you call the next order.
Order number 16, the Tobacco Control Amendment Bill, Senate Bills number 35 of 2024.
Senator Catherine Muma.
Honorable Speaker, I beg to move that the Tobacco Control Amendment Bill 2024, Senate Bills number 35 of 2024, be read a second time. Honorable Speaker, the Tobacco Control Bill Amendment Bill 2024 had its first reading in the Senate on 6th August 2024. It was then assigned to the Health Committee, which had 30 days to process the report as per Standing Order 148, and should have been tabled on or about 7th September 2024. Honorable Speaker, we are now in 2025, just about to do August, but the committee has not been able to process, even though, Honorable Speaker, I participated in the public participation process of this bill. Honorable Speaker, this is a bill that is extremely important for all families in Kenya. It's a bill that seeks to amend the Tobacco Control Act to provide for the regulation of electronic nicotine delivery system, including electronic cigarettes and related products in Kenya. Honorable Speaker, the bill in brief has amendment proposals that seek to appropriately update the definition section to ensure that new terms that relate to the electronic cigarettes and related products are defined and included in the law that guides on tobacco. It is intended to address the issue of prohibition of additives that are deceptively marketed as having implied health benefits or reduced health risks. It is intended to engage with issues connected to suitable packaging requirements, health warnings, and labeling, as well as advertising and promotion. Mr. Speaker, it is intended to tackle the problem of appropriate penalties for non-compliance. It is intended to respond to the concerns surrounding regulation of sale to minors and public place restrictions. It is also intended to deal with the matters connected to licensing requirements, regulation of importation, regulation of pricing, and commensurate taxation. It is intended to appropriately designate the regulatory oversight authority, as well as enhance the role played by the Cabinet Secretary of Health in this matter. It is also supposed to provide for monitoring and reporting, as well as research, consumer education, and the role that civil society can play in matters monitoring of these products. Honorable Speaker, electronic cigarettes or e-cigarettes have emerged as a popular alternative to traditional tobacco cigarettes, often erroneously promoted as a safer option or as a route to stopping smoking, claims that are not scientifically proven. Honorable Speaker, these devices simulate smoking and deliver nicotine through the vapor of liquid nicotine, rather than the combustion of tobacco leaves. There are different types and selections of e-cigarettes, including vape pens, bars, e-hookahs, mods, tanks, and so on, all of which are classified as electronic nicotine delivery systems, or ENDS. Honorable Speaker, e-cigarettes work by heating an e-liquid containing nicotine, propylene, glycol, glycerin, and flavors, which then produce an aerosol that is inhaled. Studies have detected volatile organic compounds, heavy metals, and other toxicants in the emissions of e-cigarettes. Additionally, in products sold in Kenya, the labeling is done only on the outer packets and is extremely minimal when it comes to the actual documents. Honorable Speaker, I've actually bought some of these documents. If you look at this, there is labeling on the packet. There is no labeling on this. And what is happening, people are buying this and then throwing away the packet and selling them at will to even minors. As I will demonstrate shortly, this is the easiest thing to buy in Kenya, online, and it is accessible even by, through the minors. Is accessible to the minors. Which are the health risks? Honorable Speaker, there are a wide range of health risks associated with e-cigarettes use and vaping. For instance, on the short-term health outcomes for first-time smokers who have never used combustion tobacco products, numerous studies suggest that vaping may increase the risk of developing chronic lung disease. In the longer term, it also worsens bronchitis, asthma, it can also raise blood pressure, and it can also suppress the immune system. In the longer term, apart from being highly addictive, early exposure to nicotine can affect learning, attention, memory, and it poses social problems among young people. Honorable Speaker, protecting the young people and minors in this country is a constitutional requirement. It is a requirement because we have also signed the Convention on the Rights of the Child. One of the 4 pillars in this convention is protection of children. Honorable Speaker, e-cigarettes were introduced in Kenya in the years 2017-2018. And if you read Section 53 of the Tobacco Control Act, it contemplates that the Tobacco Control Board, working together with the Ministry of Health, working together with the Ministries of Agriculture, Trade and Industry, Finance, Education, Information and Communication, Foreign Affairs, Internal Security, will actually come up with regulations that protect. And in my view, Lord, Honorable Speaker, 8 years down the line, with the introduction of this, the e-cigarettes in Kenya, the Ministry of Health has done nothing to put in place regulations to actually guide the trade in these e-cigarettes, the labeling and regulating on how this operates. Honorable Speaker, it is for that reason that we as Parliament, where the Ministry of Health has failed to actually carry out its job, we need to bring back that mandate and put it in the parent law to ensure that they are actually compelled to do this. When the Committee on Health did public participation, you will be shocked to hear that the Ministry of Health representative suggested that we don't need this law because they can actually regulate. And I asked the question, 8 years down the road, why have you not done these regulations? Why have you allowed these products to be on the market willy-nilly? Honorable Speaker, they did not have any answer to this question. Honorable Speaker, when we were preparing for me to present this, I actually sent my team to the market to try and find out how to buy these e-cigarettes. Honorable Speaker, these products are available very easily online. We were able to go to more than 15 websites, and buying these products is very easy. There is no age restriction. When they only ask to click whether you are 18 and above, and you know clicking can actually, anybody can click, including a 7-year-old can actually click and say they are 18 and above. There is no one of those websites that asks for age verification for one to be able to know what happens. Honorable Speaker, once you buy online, some of them offer to deliver them within 1 hour. And we actually asked for delivery, and one of my staff who looks small and looks like a child stood somewhere near KICC to receive that delivery. Honorable Speaker, when they delivered, there is no age verification on delivery. Nobody asks you, can you show me your identification to know whether you are 18 or not? They just deliver it, which means that these products are actually being sold to our children. And as many schools will tell you, and I had a chat with one of the principals in a school in Nairobi who told me she regularly confiscates the e-cigarettes and vapes in her school. And she said, I think the government needs to do something in terms of regulating these products. Honorable Speaker, we also did homework. We tried to find out whether these products are actually sold in other jurisdictions and what kind of regulation applies. And Honorable Speaker, you will be shocked to know that most of the products in Kenya are manufactured in China, but in China, the restrictions around these issues or these products is so high that you will be shocked, or I'm disturbed, that they will do a manufacturing that actually does not align to their own standards. Of course, they are doing this because the laws in China do not apply to Kenya, and it is not their responsibility anyways to put these laws and regulations in place. It is our responsibility as Parliament to put these laws and regulations in place. Honorable Speaker, I want to just tell you some of the standards that are provided for by these teams. You find, for instance, the nicotine strength that is required for any aerosol, the little whatever they sell, the pod that they sell, In the UK, in the EU, in China, in Russia, it must be equal to or less than 20 mg per milliliter. In Kenya, because it is unregulated, we have most of the ones that are selling, the three that I picked, they actually have 150% more than what is required in these other jurisdictions. When it comes to the e-liquid volume that is required per pod, Honorable Speaker, in the UK and in Russia, even in China, it must be an equivalent of less than, equivalent to 10 ml or less than 10 ml. In Kenya, it is unregulated, so most of the ones on the market are way above that. In the UK, in China, in Russia, the pod cannot have more than 600 puffs. But in Kenya, the ones I have here, the list has 2,500 puffs. We have one with 9,000 puffs. We have another one with 12,000 puffs. Honorable Speaker, this is significant because the more puffs there are, the more or the quicker the addiction comes. So they are selling these e-vapes in quantities that are so large that if a child picks it, actually they are driving them into addiction. When it comes to warning labels, in the UK, in China, in the UK, 30% of the pack must give a warning on the health warning. 35% in China. In Kenya, since there is no regulation, I've just shown you that the inside pack has no labels on it. You have a pack that is confusing. The packaging standards in the EU and in the UK require that the packaging must be child resistant, must be tamper proof in China. But in Kenya, the packaging is made sleek with flashy and flavors that are supposed to target the young people. When it comes to sales and licensing, Honorable Speaker, all nicotine-containing products must be reported to the medical and health care products regulation authority in the UK and in the EU. In China, they actually have only the state monopoly, a state monopoly that actually a state-driven authority is the only one that can actually license and sell these products online. In Kenya, as I've just told you, you can buy these things as easily as you want. When it comes to online sales, in China, they are prohibited. You can only buy online if you're buying from the government authority, which regulates who sells that. In the UK and in the EU, it is legal to buy online, but it is now being regulated. In Kenya, as I have said, you can buy it as you wish. In the UK and in the EU, they enforce age verification. In China, they also have age verification. In Kenya, as I have told you, we actually manage to buy just by clicking on a website, and when they deliver, they don't even verify whether you have an ID. Nobody asks for the ID. Honorable Speaker, what does this mean? It means that companies that produce these things are actually taking advantage of Kenya, maybe not just Kenya, but Africa, where we are slow to actually put law and regulation in place to guide this issue. Kenya has no enforcement caps on nicotine concentration. Kenya sells ports that are way above the number of puffs. Kenya has no edge production, edge protection and access protection, and the sales are free for all in Kenya. So, Honorable Speaker, this law is a law that is intended to actually bring sanity in the operation of these products. Honorable Speaker, it is the responsibility of every person in this country, including those ones who are selling. I don't think anybody who manufactures this would like their 80-year-old to go puffing away on these issues. I don't think those in the Ministry of Health can look us in the face and say it is okay to leave these products to actually be accessible willy-nilly. So this law as provided, I am urging colleagues to support it, to contribute, to suggest any amendments that can actually strengthen it, and to collectively resolve that it is important, if we care about our children in this country, to actually put in place regulations to save our. Honorable Speaker, as you are aware, I like to speak for adolescents. I like to speak for the children, for the reason that the legalities around their age, reference to them as minors, means that their protection is in the hands of others. As we represent in this house, we need to understand that the people we most need to represent are people like the students who are sitting in the gallery today, to be protected from being targeted by those who do drugs, by those who actually are targeting them in terms of getting them hooked on these e-cigarettes through the cozy flavors that they are providing. And by the way, I forgot to say, in China, the only flavor that you must have in vapes is a tobacco flavor. You cannot come up with the strawberries, the melons that we have here, the ones that are actually intended to hook our learners and our young people into taking on this habit. And as I speak, I hope that our learners can actually know that much as it looks like it is cool to actually vape, to engage or to smoke the e-cigarettes, these are harmful to your health, and they are likely to actually cause a lot of disruption, including diminishing your intellectual capacities over the years. So as I sit, I'm urging my colleagues to actually support this bill, to look at it, to scrutinize it, to actually resist being targeted by industry to kill it, because I know that is one of the things that is happening. The industries on these issues like to dump the highest addictive products in Africa. It means they don't care about our children. By the way, there is one product here that is being sold, and it says not to be sold in America or in China. Where is it made? It is made in China. But they are saying it cannot be sold in China or America. What does that mean? What do they think about your children? Do we just embrace them and decide there is a business here? Should we be in the business of killing our children? Should we be making money over killing our children? I'm requesting colleagues, kindly read this, give us the objective comments on this, and allow this law to pass. I will be urging colleagues in the National Assembly to also allow it to pass, so that as soon as possible, we can actually remove the shame on Parliament. 8 years since these products came to the market, The Parliament has failed to ensure regulation. Parliament has failed to protect children from these products. So with all those remarks, I move and request Senator Veronica Maina to second. Thank you.
Senator Veronica Maina.
Thank you, Honorable Speaker. And at the very onset, let me take this opportunity to congratulate my colleague and friend, Senator Kathy Muma, for bringing such an important bill which goes into improving the welfare and the health of our nation. And why do I say that? Because we know the harmful effects of nicotine can only lead one to an early grave. Honorable Speaker, the bill that has been proposed to this House is one day too late. It should have been done before, because Kenya has been made a playing field by what Senator Kathy has called merchants of killing our population. Indeed, it is so unfortunate, Honorable Speaker, that this bill comes at a time now when it is supposed to respond to the concerns surrounding regulation of sale of nicotine to minors and also to control what is happening in the public space and restrict the use of nicotine, e-cigarettes, and all products that are in this range. It is also very unfortunate, Honorable Speaker, that even as our nation, we speak about impunity, and people tend to define impunity as something that is being done in the political arena. It is unfortunate that even the businesses that are being traded here within the Republic of Kenya have displayed and have shown and demonstrated a lot of impunity. Because, Honorable Speaker, if a tobacco product has already been banned elsewhere, how do they find access to our nation? I think one of the aspects that need to be regulated and institutions that need to be called into account are institutions like KEBS. Because if a product, and we have had this challenge, not only in this area, we've also had this challenge of products like pesticides, which are banned in other countries, finding themselves being sold in Kenya on open shelves, on open counters, Honorable Speaker, without anybody even standing to say no to the sale of anything that is harmful to the public health of our nation and also harmful to our children. Honorable Speaker, that's why this bill is very timely, one day too late. And because I'm sure many people know what my stand is on matters alcohol, matters tobacco. In fact, I proposed to Senator Kathy before we came back this afternoon, this bill should not have read the Tobacco Control Amendment Bill. I would have actually been very comfortable to second you on a bill which is titled the Tobacco Ban Amendment Bill, whatever that would stand for, or the Tobacco Ban Bill 2024. Because I actually don't know the reason why people smoke. I have been next to people who are smoking, Honorable Speaker, and especially the chain smokers. Don't ask me where I was, because I live in a normal community where I have friends, relatives, colleagues who definitely sometimes are smoking, Honorable Speaker. And sometimes as they smoke, I listen to how they are coughing, and you can tell their lungs are almost out because of the harmful effects to the health of the smoker, and the more harmful effect to the people who consume the smoke that comes from what is being smoked. And now we have the e-cigars, new emerging products in the market, being sold online, undeterred and controlled, being purchased by anybody from 10 years old, 12 years old. How shameful can this ever get, Honorable Speaker? And I'm happy that this tobacco control bill is going to ensure that, first of all, you cannot sell these products online, especially the ones that have nicotine. Nicotine has cancer-causing elements such as ammonia, chromium, formaldehyde, nickel, pH adjusters, and nicotine salts. They are all cancer-causing elements that should not even be consumed by a person who truly understands what is contained in that cigarette. So, as I stand to second this motion, my plea would be to all the smokers. Consider how you can withdraw from the smoking, first of all, because it's very harmful to your lungs, it's harmful to your health, and it reduces your life expectancy. So one, I would say, it is not worth smoking. Two, it is criminal for any trader to purport to sell those products to underage children, unprotected. Can you imagine, Honorable Speaker, as you are seated today in this Senate, you are 14-year-old or 15-year-old could be ordering a nicotine product online in your absence without anybody controlling them. And you know, our children sometimes are in boarding schools, they will go out. Can you imagine the delivery that was done to Senator Kadhi's young worker at, I think you said that wherever it was that it was being delivered, it was being delivered at KICC. Nobody monitors. The parent is not there. But the person who is so keen to sell that product happily takes the order to that young person. Where the young person consumes that product, you cannot tell. And Honorable Speaker, what is being sold online to underage is shocking in this republic. One time, Honorable Speaker, when we were in Canada, we saw shops across streets when we were in the course of some conferences we were attending. We saw shops, and many of them where they are selling even cannabis sativa, Honorable Speaker. They are selling marijuana. They are selling anything, and there is a freedom for them to purchase that. Is that the direction we would want our nation to go? Of course not. So we need to have control on what is being sold, an informed and very intelligent way of determining how harmful the products are, so that if it's not accepted in another jurisdiction, definitely it shouldn't land in the Republic of Kenya. And we truly want to call upon, the KEBS to ensure that they control the products that are coming from out. And I'm happy to note that on 31st May this year, the CS for Health, Honorable Duale, suspended existing nicotine products import and distribution licenses. He suspended those licenses. I wish they could stay suspended, and they were asked to reapply again for assessment as to whether they should be allowed to sell those products here. So the regulations I've seen, the controls that have been proposed in this bill are quite good, because even the premises now will be licensed and will be subject to inspections. The county government, you have powers to ensure that licensing is being done. There will be a full disclosure of the person who is manufacturing the product. The importer of the product also will be disclosed and open. There will be warning notices on the health risks that are attendant to the use of those products, so that if somebody is consuming or is smoking those products, Honorable Speaker, they can tell whether cancer is knocking or cancer is a few months away from giving them a visitation. Honorable Speaker, I have also seen now a clear definition of areas within this bill where smoking will not be allowed. And I'm happy to note in section, let me get this, section 15 of this bill, under section 15 of this bill, there are many places where without prejudice to the generality of the subsection 1 of section 15, smoking is permanently prohibited in the following areas: institutions of basic education and training, places of worship, hospitals, clinics, and other health institutions, children's homes, childcare facilities, children's playgrounds, residential houses, and such other premises where children are cared for, public service vehicles, passenger vehicles, school buses and vans, commercial passenger aircraft, commuter boats, ferries, and police cells, And smoking is prohibited in the following areas except in designated smoking areas. And it details out all the areas where you cannot just go to a restaurant and smoke. So I hope unless those designations are done, a person will not be allowed to smoke in offices and workplaces, court buildings, factories, cinema halls and theaters, police stations, prisons, aircrafts, education facilities, railway stations, markets and shopping malls, retail, stadia, sports and recreation facilities, and public building. And Honorable Speaker, as those areas are being detailed out, let me also point out, it's actually very wrong and very bad manners for anybody, even a guest visiting you, coming to ask for a place where they can proceed to smoke. Because if the rest of the people in that home are not smoking and there are children within the residential areas, then don't push your hosts by asking whether you could smoke inside their house, because some may not be able to tell the smoker that we don't like that, because they will respect you as a guest, but it is wrong to smoke in somebody's home. Honorable Speaker, I would also wish to raise the issue of how other products are being packaged. Other products that have been smoked before are now being packaged in sweets, in cookies, like marijuana, bang. They are being, they are packaged in a different way, such that even the children are so exposed that your child will be given a chewing gum or will be given just something that doesn't look like a drug. And what is packaged in that sweet or ball gum or whatever it is actually a very harmful product. And I would want to say to the children, because I can see we have some from a school today in Senate, don't eat any chewing gum or anything that you receive in a party. Just eat from your parents and people that you're very familiar with. Because suddenly the packaging is no longer the traditional conservative packaging that is given for purposes of, just having a candy. The candy has turned into something else. It could be anything packaged in that, including drugs that could take you out. So don't be eager to eat anything from people you do not understand. Honorable Speaker, I would hope that all the senators in the House today, and even those who will hear us from online or from the recording of the submissions today, will support this bill, and unanimously we will send a statement to the merchants of death who are trading with wrong products on our young generation, that time has come for all of us to turn around and to say no to this nicotine product, to accept the control and the regulation, and to ask the Ministry of Health, Ministry of Public Health, the Ministry of Trade to be very, very, very firm on the products that are being brought to this country. It is very wrong, Honorable Speaker, for us to allow products that have heavy metals, metals that are causing damage, health damage to cancer, to kidneys, to lungs, metals that are causing health damage to organs of the body. In fact, we saw one of the notices we saw in Canada on one of the products that was being sold was a notice that there was the risk of lungs being frozen after consuming that product for about only 3 months, Honorable Speaker. And if a product is that bad, why then should anybody be eager to buy or consume such products? So, Honorable Speaker, I submit that e-cigarettes must be controlled. They must, and even other forms of vape pens, bars, e-hookahs, mods, tanks, and any other product by whichever name is brought to our market. We must be strong enough to say what we need and what we don't need, what is beneficial to us, what is not beneficial to our system. And Honorable Speaker, to finally note that anybody who is consuming some of these combustible tobacco products, including the vaping, will have a worsened situation if they have bronchitis and asthma. It raises blood pressure. it suppresses the immune system, and it increases the risk of developing a chronic lung disease. And you know, some of these ailments, Honorable Speaker, recovering from such ailments becomes a very tall order. The research in the medical field has not given cure for some of those ailments, and it is not good to gamble. And finally, these products are very highly addictive. Once you get hooked, or somebody gets hooked to these products, and a very early exposure, it will affect everything. If it's a student, the learning stops, the attention becomes very difficult, the memory is affected, and you also have social problems if you're a young person. So the best thing is to ban. That's why I was proposing to Senator Kathy, that she should have brought in the tobacco ban bill, but since it has come couched as the Tobacco Control Amendment Bill, I hope the control then would ease off and reduce the risk, but on a bare minimum, we must accept that these products must be controlled. And let me also mention, there is a town in this country, Kijabi, where I'm told they don't smoke and they don't drink. Up to now, Honorable Speaker, and I'm not very young, I am yet to hear anybody who has died because they did not smoke or they did not drink. Kijabe is doing so well, and I want to appreciate the residents of Kijabe for keeping their town very free. In fact, the government should incentivize Kijabe. All the roads should look very good. They should be a model town for a place where people have survived without smoking, without a single bar, and everything has gone on very well. And if a research was to be done, you might actually find, Honorable Speaker, that without the alcohol addiction, without addiction to smoking, without addiction to drugs, they will have fewer accidents, happier families, they will be more healthy, and it will be an attractive place to look at for socio-economic and political development in such an area. With those very many remarks, I beg to second this bill. Thank you.
Now, Honorable Senators, I now propose the question that the Tobacco Control Amendment Bill, Senate Bills number 35 of 2024, be now read a second time. Honorable members, this motion is now available for debate by members, and I believe the members were in the House, though I am unable to see any request. I believe the system is down. I will allow Senator Olekina to present his submissions to the bill.
Thank you, Mr. Speaker. Mr. Speaker, I rise to put in my 2 cents on this amendment, which is brought by my dear sister, Senator Moma, on the Tobacco Control Amendment Bill 2024. Mr. Speaker, earlier on today, we spent about 3 hours in my Committee of Health, and I feel bad that this bill has been moved before my colleagues in the House have an opportunity to be able to understand what the industry, what the stakeholders who this very parliament carried out public participation to be able to seek views on what my dear sister is seeking to do. I'm going to try and summarize the areas which I think my sister, Senator Moma, is trying to deal with when it comes to the issue of the tobacco control amendments. Number 1, Senator Moma is asking that we look at the issue of the public health impact on smoking, particularly for the younger generation. Number 2, Senator Moma is asking us to amend the levels of nicotines which are put in any delivery system of nicotine. Senator Moma is suggesting that currently having high levels of nicotine in cigarettes, or even in any nicotine delivery system of 20 milligrams, which is what the industry is pushing for, is creating a lot of addiction, particularly to the younger generation. And one of the recommendations that Senator Muma is coming up with in her bill is that we reduce the levels of nicotine from 20 ml to 10 ml. The industry, on the other hand, is saying no. They're saying they have presented various submissions and arguing that international standards requires 20 ml. We have looked at other jurisdictions, and we've seen that other countries like maybe the US or the UK is around 15 ml. So it's not really 20 ml. Senator Muma has also introduced issues of taxation in terms of the levies on who should be able to benefit on the levies of this issue of cigarettes. She has also alluded to the issues of approvals, testing of the cigarettes, and approval. We looked at all those avenues. Some of them I have very strong opinions on, and because of time, I will try to summarize my submission on, and I hope that they can be able to help my colleagues who would either listen because they are not here, and those who are here, to be able to understand the areas, because sometimes I think we lose focus because of our own prejudices on the issues that are being discussed. The committee, and I think I'll be jumping the gun here by discussing some of the areas that we're talking about, considered and agreed with Senator Muma that it is imperative to reduce the amount of nicotine in any nicotine delivery system, or even in cigarettes, from 20 to 10. That is a big argument that, of course, we are going to be having. And I heard Senator Muma saying the industry has been really lobbying to make sure that Parliament does not pass these kind of amendments. That is one of the biggest tug of war that we're going to be having. And it is imperative that people understand why reducing the levels of nicotine is important to safeguard future generations. The second point, which we deliberated on earlier on today, is the issue of flavors. And Mr. Speaker, you'll allow me to use the right Swahili word on this matter, because the way we looked at it is that Senator Moma has said that in China, there are no flavors. In China, the regulations are stricter, but here, they are not strict. You know, it is like when you do away with the flavors, it is like smoking what we used to call kraiko, where when you enter from a distance of about 20 meters, people will know that you're a smoker. But the moment you now add a flavor of strawberry, vanilla, you can be able to dupe people that you've just been enjoying a good vanilla milkshake or a strawberry milkshake. You know, for me, I looked at it in two ways. Whether you're a smoker or not, whether we can tell from 20 meters that you're a smoker, I didn't see any problem with having flavors, because you will still smoke. Either, in fact, we talked about, you know, the ministry was proposing that in this bill, we extend the definition of this bill, of this amendment, not only to deal with nicotine substance, but even other products that do not contain nicotine. And I'm sure those in the ministry were thinking of marijuana, because there's no nicotine in marijuana. There are other chemicals in it. So the issue here that we all must consider and must sit down and really deliberate on is whether or not to allow this issue of flavors. There was also another issue, Mr. Speaker, on the issue of using reusable, I don't know what you call them, versus, you know, those, what are they called? I think the pods, yes. Either reusable or those ones which are disposable. That is the biggest issue. And the biggest debate, Mr. Speaker, which is important for us to understand in this bill and what Senator Moma is looking for, is that the industry is saying, no, we do not want to use reusable because they are also coming up with the issue of health issues. We want to use disposable. So there is an issue of profit versus public health. So those are the two main arguments that all of us must be reduced to, contemplate, to be able to come up with a good legislation that will guarantee the future of the cigarette industry in this country and also the future of our youth. Mr. Speaker, there is no doubt that we must develop strict and stricter regulations to be able to control the industry. Some of us were actually of the idea that whatever funds, whatever amount of money that is paid, either for approval, because we saw it fit to divide the approval process and the testing process. In the bill, Senator Momo, and I would suggest that you come up with this amendment, we have to separate and put a two-level where the testing is strictly done by KEBS, Kenya Bureau of Standards, to be able to test the levels of those nicotines. If we now say that we are going to reduce from 20 to 10. Number two, I hate the fact that we are ending this because I really wanted to be able to articulate this, but I only have 30 seconds. But in those 30 seconds, let me put it this way. Hopefully I'll have more time. We are going to separate between the testing and the approval. The ministry does not have the capacity to test. KEBS have the capacity to test. The money that comes out, our colleagues were even of the opinion, which I subscribe to their school of thought, that the money which is paid by either the importers, either the manufacturers, should actually be put in the kitty of SHA to be able now to focus on preventive, because there is a fund, and this bill talks about that fund. It talks about a tobacco fund, or is it, I don't know, preventive fund.
Senator Olekina, I would love to have you conclude your comments on this particular bill tomorrow when we resume. You still have got 11 minutes to dissect and align with the bill from Senator Muma. Now, Honorable Senators, it's now 6:30 p.m. Time to adjourn the Senate. The Senate therefore stands adjourned until tomorrow, Wednesday, 30th of July, 2025 at 9:30 a.m.